He's fine.
One second, and we will pivot. All right, our 10 o'clock calendar is all about probation revocation, sort of. There's some inquiries and a bond hearing. So actually it's a mix. But let's start with the first one because it said evidentiary hearing. I hope it's a quick one because we've got an 11 o'clock calendar as well. And I have to leave a little before noon to pick up the same kid to bring him back here for another afternoon of misery for him in the courthouse. So that's Garnett Davis. Is Mr. Davis here? Okay, you don't need to bring him out yet. I want to get a forecast for what we're doing. I have his warrants and we can get on them when we need to, how much time remains, et cetera. But I think when we were last together, Mr. Davis had indicated because the basis for the revocation was an allegation that he committed an armed robbery and aggravated assault. There's also the technical violation that he didn't show up for a meeting, that he wanted an evidentiary hearing. Ms. Wood?
Good morning, Judge.
Good morning.
I spoke to Mr. Davis this morning. I believe we're going to resolve that short of a hearing this morning.
Okay. Should we bring him out now? Any reason to not go in the order this next calendar has?
No, Your Honor, I believe that should be fairly brief. The state will have a recommendation and then Ms. Wood will.
Okay, we'll do it the standard way. I just wanted, if we were going to be bringing in officers or victims, we needed to get rolling on that. All right, so let's bring Mr. Davis in and we'll get on the record.
Thank you.
All right, let's go on the record for Mr. Davis, who has just joined us. This is indictment 16 SC 143862 and 19 SC 169534. I have probation warrants for Mr. Davis in both those cases. Mr. Davis is here in court with Ms. Wood. Mr. Jordan is handling this for the state. Ms. Tucson, can you please get us started by letting me know how much time remains on each of Mr. Davis's cases?
No problem. Good morning.
Good morning.
On the 16 SC 143862, he has 5 months and 16 days remaining.
All right.
And on the 19 SC 169534, 1 year, 3 months, and 5 days.
And are those the only Fulton probation matters you're aware of?
Yes, Judge.
Okay, thank you.
No problem.
So, Mr. Davis, good morning. The two petitions that I have seeking to have your probation revoked allege, they're the same, that just because you have two cases, there are two of them. They allege that in July of last year, you committed an armed robbery and aggravated assault here in Fulton County. And then a few months later, you failed to report to a meeting with your probation officer in October of 2022. Those are the allegations. Mr. Jordan, what is the status of the armed robbery? Has it been indicted?
The last I checked, Your Honor, it has not been indicted yet.
Do you have a CP number? It may be on my calendar, but
Actually, Judge, I think there's a very recent indictment.
there is. Don't know that it's the same thing. I don't mean to talk over you, but I see that. Keep going.
I believe, if I'm looking at the right thing, there's two newly indicted cases assigned to Judge Eaton's courtroom.
Oh, there is a second. You're right. They're both there. There is an armed robbery. So that would be the 23 SC 186950 would be the armed robbery. And then there's a 952 that's an entering auto. That's the one I saw first and said that's probably not the same case, but got it. Okay. So yes, Mr. Davis has been indicted for the armed robbery. I'm assuming that's the same scenario. We'll have to, let me just look.
I believe so, Your Honor.
If the dates line up, Judge.
They do. Okay, great. If you've checked that, then that's the same situation. So, Mr. Davis, you've been indicted, and your cases are assigned to Judge Eaton. These cases are with me because the judge who sentenced you in the aggravated assault, and it was at least back then an armed robbery in 2016, and then the theft by receiving from 2019 was my predecessor for this docket. So that's why you and I are working together on this. Okay. Ms. Wood, is Mr. Davis stipulating to these allegations, or what's our process? When we last spoke, maybe we're going to have a mini trial on it, but it sounds like things may have changed.
He's stipulating to the arrest, Judge.
Okay. So in light of that, why don't I start with you, Mr. Jordan? What is the state's recommendation as to these two matters?
Your Honor, on the 16 SC matter, the state's recommendation would be to revoke the balance on that case since it is only 5 months and some loose change of days remaining. On the second case, we would ask for 1 year to be revoked concurrent with his 16 SC matter.
Okay.
And we would ask that both of those be closed, Your Honor, since there would only be 3 months remaining on the 19 SC case.
Okay, so the 16 would close anyway because you're revoking the balance. You're saying suspend the balance of the 19 SC upon completion of the term and the term of revocation and close that case out.
Yes, Your Honor.
Okay, and I see Mr. Davis has already done, this calendar's printed a little while ago, so a few months worth of whatever revocation is in place.
Yes, Your Honor.
Okay, got it. Ms. Wood, your recommendation.
Yes, Judge, we'll agree on the 16 SC case to revoke the balance. I
Mhm.
think he's already served that. He's been in since December the 8th of last year. And then on the 19 SC case, we're asking the court to consider revoking 6 months, credit for time served, and then of course close out. He does have a bond on the new armed robbery. I'm not sure if you can make it or not, but I didn't share that with the court.
Okay, I'm looking it up right now. Okay, right, he got a bond in March. He had been in for more than 90 days without indictment. Okay. Got it. Okay. Mr. Davis, anything you want me to know, or I can rely on what your attorney had to say? Okay, we're good. All right. Mr. Davis, in light of your arrest and subsequent indictment for armed robbery, and it's now indictment 23 SC 186950, case assigned to Judge Eaton. I will revoke your probation. Getting arrested for that and then ultimately charged through the grand jury is a violation of your probation. I understand fully you're not admitting you did those things. You've got the presumption of innocence in your favor in those two indictments. And frankly, one of the indictments isn't really before us now. Anyway, there's nothing in this petition about an entering auto. But we do have the fact that you were on probation for, you see what that ended up being pled out to. Okay, so it was reduced. It was 2 counts of armed robbery that were reduced to robbery, and the aggravated assaults still were aggravated assaults, but you got 10 years to serve 3 with the balance probated per Judge Downs. Okay, all right. But given that you were on probation for that and this new situation came up, I do think revocation is appropriate. In 16 SC 143862, I will revoke the balance. That's the 5 months and 16 days or whatever the balance may be. That's what Ms. Tucson did the math at. You'll get credit for the time that you have served since what's the significance of the December arrest date?
That's 153 days, Judge.
Oh, but what happened in December?
Oh, I believe that may be when he was picked up on.
That was when he was arrested on the armed robbery, December 8th.
Okay, even though it was a July situation, it was a December. Okay. Let me just look in here. Okay, I've got December 8th is when he was booked in. So you'll get, and that is 153 days. So you'll get credit from December 8th forward, and that will close out the 16 SC. In the 19 SC case, I'm going to follow the state's recommendation and revoke 1 year. You'll get that same credit for time served, and I will suspend the balance. So when the revocation is done, that case will be closed out as well. You will not be under supervision for either of those cases in Fulton County. You have these 2 new cases you need to work through with Judge Eaton, but you've got a lawyer already appointed to represent you in those, and those will begin to move forward. Ms. Tucson, do you need any more information from us?
No, not at the moment. This information will get sent over to his officer, and since the balance will be suspended, he would only have to report if he receives probation in his new cases.
His new cases. Okay, and you'll get the revocation orders to me.
That's correct.
Great. All right. Thank you so much. All right, let us shift to, do we have Mr. Adams? We do. Mr. Adams, are you ready for the bond hearing with Mr. O'Neill?
Yeah, Derek Wright is also on the case. I think President or will be.
Say that again?
Derek Wright.
Okay. Is that a witness you're going to be calling?
No, he entered appearance as attorney.
Oh, Derek Wright. Oh, Derek Wright, meaning he is representing Mr. O'Neill with you?
That is correct.
Okay. Do you want us to hold for his report?
Yes, sir, please.
Okay, then we'll move on and turn to position 4. And Ms. Ogbamudia, you're going to need to remind me, I forgot you prefer a different last name. It's not on the calendar, and you need to remind me of that so I can at least address you that way. Of course, your indictment is under that name. Irvin? With a G or just an N? All right, Ms. Irvin. So, Ms. Irvin is here. Ms. Irvin had a case in drug court. She was terminated and asked that her case, it was track 1. So it was a diversionary case. She asked that it be moved to my criminal docket. And we need to figure out how to move Ms. Irvin's case forward. It ends in a 5. Is that a Ms. Feely case? Have you and Ms. Irvin had a chance to speak yet?
I wasn't sure, yes, I did meet her, but
Okay.
I haven't spoken with her in detail about the case yet.
All right, let me look in the docket to see if it was ever arraigned in non-complex or if we ought to just reset that.
There was a waiver filed, it looks like in November. So that's November 2021.
Okay, but I mean, it's still a waiver of arraignment. I don't know that we need to do it twice. We could just, because of that, and it was with the fancy font, a colleague of yours. So we've got that. Ms. Irvin entered her plea of not guilty. So does it make sense just to do a scheduling order? This is hopefully a fairly resolvable case, but we need to have it move in the normal pathway in this division. It'll be a pretty short runway because I can't imagine there's much discovery, and it may already have been provided, but if it's easy for the state to re-provide it, they'll get it to you directly, Ms. Feely, so you don't have to hunt for the file from Ms. Finley. And Ms. Irvin's on bond, so we don't have an issue there. Anything else we need to cover for today?
No, I'm gonna get some updated contact information from her.
Okay. So Ms. Irvin, I know you got to meet Ms. Hankins in the past. That was the public defender assigned to drug court. Ms. Feely and Ms. Wood are the 2 public defenders assigned to my criminal docket. And because of they divide their cases by numbers. Because of the last digit of your indictment, you'll be working with Ms. Feely. She's going to need to make sure she's got the best ways to reach you. I want to make sure we're current with your address. Is the street, is it Humphreys Drive? Good. Okay. So from the court, you'll only get something in the mail. We don't call you directly. Ms. Feely may need to call you directly to say, hey, you got to come look at this discovery or whatever it is she's going to want to talk about. So please give her your best contact information and she'll give you some contact information. And then when I see you next, it's either going to be because Ms. Feely has filed some motion, like a motion to suppress, or the case has been worked out. And we'll get you in here and it'll be whatever it's going to be. Do you have any questions? Okay, great. When Ms. Feely says you can go, you're good to go. Kadareems Bradley.
She should be on the Zoom, Judge.
Let's look. Maybe the iPhone?
Miss Bradley, yes, she just emailed me that she was on here, so.
All right, Ms. Bradley, if you're there, can you?
Hello, I'm here. How you doing?
Well, let me get, there we go. Excellent. You're in Mississippi right now?
Yes, sir.
Excellent. Okay. So tell me, Ms. Wood, what we're doing today with this case. Not a new case, but maybe there was a bench warrant.
Judge, I believe, yes, so this, I filed a motion to set aside the bench warrant. This is an old case. I believe, I don't have the incident date right in front of me, but I know it's at least, I think it's actually 2019, if not 2020. I was hoping Mr. Jordan and I would have a chance to maybe try to resolve this case, but I understand I don't want to keep Ms. Bradley sitting around all day. So that was the main thing, is that I wanted to ask the judge to consider setting aside the bench warrant. They moved right after this arrest to Mississippi and have been there ever since. And I believe it was when a job application went through and was rejected. This was put on the radar.
I'm looking at the indictment and okay. So there was a co-defendant, Mr. Jones. Looks like he's resolved his situation. This is from November of 2019. Do you have any objection? Well, let me take a step back. Do we now have good contact information for Ms. Bradley?
Yes. I believe I did a change of address, or I don't see one filed, but I will make sure.
Yeah, you'll want to do that because it has an address of Olympian Way.
I will get that to Ms. Nelson today, Judge.
Okay.
New contact information.
And Ms. Nelson is pointing out that it's not clear that Ms. Bradley was, I don't know if this was a direct indictment. She doesn't have any info that Ms. Bradley was ever arrested. And so I don't know how we process that. I'm fine. I'm going to get input from Mr. Jordan in a minute, but conceptually, I'm fine lifting the bench warrant once we've got good contact information. And I guess it depends on how this case is going to be resolved, but I don't know if there's a grand jury warrant rattling around out there or what. That's different from a bench warrant, but it may be that Ms. Bradley has to go through the booking process. So you'll want to figure out that situation.
In Your Honor, the state would have no objection to the bench warrant being set aside. And I also, as to what you were saying, I don't see that there was ever an arrest made. It looks like
it says, I just looked at the indictment, big bold letters, direct indictment. So Ms. Bradley hasn't been arrested. I don't know if there's a grand jury warrant out there, if those automatically issue when a direct indictment occurs. But we can have Ms. Wood look into that, and if we need to work through that as well. We can't skip a legal requirement. If Ms. Bradley has to be booked in some way, we'll need to take care of that, depending on how this case is going to resolve. All right, so I'll lift the bench warrant. Do you want, Ms. Wood, a chance to talk with Mr. Jordan? Ms. Bradley doesn't need to stay on the call, but she could plug back in later this morning or even this afternoon. Mr. Porter's hearing is not going to take all afternoon. So if there is a way to get closure today, I'm fine helping with that. If it's just that's not practical, then we'll just need to plug Ms. Bradley back in, thinking through if it is a resolution where there's a plea being entered, Ms. Bradley probably needs to come here and get booked in and out all in one fell swoop.
Yes, Judge.
Okay. So how do you want it? You want a chance to talk with Mr. Jordan and get
speak to him after our other calendars, and then I have really good communication. I can email Ms. Bradley if I need her to pop back on Zoom for anything.
all right. So you'll do a change of address and you've got all the current information?
Yes. And I'm gonna get that to Ms. Nelson today.
Okay. Ms. Bradley, do you have any questions? We've been talking a lot about your situation.
Yes, I have a question. If this get resolved today, will there be a way that the court can go ahead and lift this off my record? Because like I said, like I told Ms. Woods, before. That day after court, when the judge said I had to leave, I left that night. I wasn't in Georgia, so I never got anything about court or anything because, like I said, I moved. I'm literally sitting in my house that I bought.
Yep. Okay. No, I understand. So one, I'm going to lift the bench warrant today or tomorrow, so that'll be gone. There shouldn't be an active warrant for you. There's still these charges, but that's where you and Ms. Wood will need to talk after she speaks with Mr. Jordan, the prosecutor. So what I can tell you is we'll get rid of the warrant, but not the charges. Those will need to be resolved in some way. And there are lots of different ways they can be resolved based on their age and the steps you've taken to get yourself out of the situation that resulted in whatever.
Yeah, I started my own trucking company. I mean, I'm not, that's the hindrance that I have. I can't further my trucking career because of this incident, something that I did not know anything about.
Okay, well, I don't want you to get into the facts and circumstances of what happened with Randy Daniels, because that's for another time. But what I'm going to do is let you go now. Ms. Wood will be back in touch with you today at a minimum to say, here's the next step. But it could be, hey, I need you to get back on Zoom because we're sorting the case out, assuming that's what you choose to do. Okay?
Okay.
All right.
Y'all have a nice day. Be blessed.
All right. You too. All right. We'll take care of lifting the bench warrant, and Ms. Wood, you'll take care of the change of address. I don't want this to fall off anything. I guess, are you going to waive arraignment for Ms. Bradley so that, well, you already did, I think. You did. So we'll do a scheduling order. Yep, you did. So we'll do a scheduling order, and that'll move it along at a high rate of speed, but maybe something will get taken care of.
Yes, Your Honor.
Okay. Mr. Adams, I don't see Mr. Wright in court or on the call. Do you want to give me an update on that, or do you want to do this? We've got time. My next calendar is not till 11. So I may just go do some work, and then when Mr. Wright's available, we can take care of this.
Yeah, I called him and he said he's gonna call me back in 10 minutes and get the Zoom link and come on that way. I do know he wants to speak to Mr. Jordan.
Okay, and this is about Anthony O'Neill.
That's correct.
Okay, got it.
Is Mr. Jordan available? Is he there?
He is. He's sitting right here.
Okay.
All right. So then why don't we will take a break. I will come back out once Mr. Wright is available. If that doesn't happen before 11, I'll come out a little before 11 anyway, because we've got a plea and arraignment calendar. I'd love to start now, but I don't know. We have a bunch of folks who aren't late yet, who aren't here.
So position 8 is in the hallway, Brandon Harris, but before I file an entry and waiver of arraignment, I'm not sure we should have this. There, not only are there no felonies, but there are no Title 16 crimes. It's all moving violations.
Let me look. We had one of those recently. I'm not going to remember his name, but he's got an unindicted murder.
Mr. Bruce.
Yes, Asante Bruce. So I'm going to read the last of the 4 statutes. So far, it's 3 for 3 with misdemeanors. What is is it sort of like with a civil case? It's a motion to transfer? Like, what do you do with a all misdemeanor?
I'm happy for the change of pace, but
Yeah, but you got a few other cases. Yeah, so hit and run can be a felony, but only if there was a death or serious injury. I guess we had a trial on one of those. That's not this case. At least there's no allegation. The way it's alleged, it basically doesn't say it, but it charges it as subsection C1. So not serious injury or death, but just injury. And that's a misdemeanor. So unless it was, no, it's all misdemeanor. So, yeah, I don't dismiss it. The answer is it's here, unless I guess the DA's office chooses to null pros it, or I don't know. You can't transfer an SC to a CR. It's a different docket. So I don't know how it ended up here. There was one other charge, which was speeding. That wasn't presented to the grand jury. It lists count 1 as a felony in the system. The fleeing or attempting to elude.
That's what I went by.
Yeah, but I just read that. 395. Oh, wait a minute. It's a felony. It's just, well, it's interesting. Yeah, no, they just didn't cite to the penalty phase. But if you flee or attempt to elude an officer and you operate your vehicle in excess of 20 miles an hour above the posted speed limit, that's a felony. And what is alleged in count 1 is that Mr. Harris, in trying to elude the Georgia State Patrol, operated his vehicle in excess of 20 miles an hour above the speed limit. So it's in the right place. Do we want to handle arraignments that we can now for folks who are here?
yes.
Since we're all together? So we'll go in, we'll skip number 1, number 2, number 3. Is that a colleague of yours or is that private counsel?
As a private attorney.
Okay.
She's with us.
She is, okay. So is Mr. Kilgore here? Okay, he's not late yet.
I'm gonna go see the people in the hallway if you don't mind.
Oh, okay.
Judge, I can make an announcement while we're waiting.
Sure.
Position 10, Brittany Davis.
Yes.
So I waived her appearance. She had court today in Cobb County. So I have good contact with her. I believe I also I know I filed the waiver, I think I also updated the address. But I just, let the court know.
Okay, so you have waived arraignment for Ms. Davis. She's not here. She had court. What's going on in Cobb County, wherever you said?
It sounded, I really didn't understand. It doesn't sound like a criminal matter, but
Okay,
I don't know. I'm not sure exactly.
all right. So we can do a scheduling order for Ms. Davis.
And I did update her address in the system.
Great. Okay. Any other announcements?
Not at this time, Judge.
All right. Mr. Jordan, who's going to be covering for Ms. Hall today, or is she going to be dialing in?
Your Honor, I can cover for Ms. Hall.
Okay.
Oh, Judge, I actually do have one more announcement.
All right.
Position 4, Charlie Neal.
Yeah.
I also waived his appearance today,
Okay.
and I believe confirms the address, but I'll just double check.
And Your Honor, just to be clear, I'm not sure if Ms. Hall is going to appear or not, but if she, in the case that she does not appear.
Okay. Yeah. She, again, no one's late yet, but I just know she was going to be on leave. So if it's going to be hard for her, then I want to make sure someone was here.
Yes, Your Honor.
Okay. So, position 4, we'll get a scheduling order out.
Thank you, Judge.
All right. So Ms. Feely, did you find, is Mr. Kilgore here?
Not finding Mr.
Not yet. Okay.
We have position 6, who we can speak to while the court is in recess, and position 11.
Okay. So Mr. Muhammad, though, I thought was private counsel, is Darnelte Russell. Hey, Mr. Russell, have you hired Mr. Muhammad as your lawyer? Okay, great. Well, he's not late yet, so hopefully he'll be here in about 20 minutes. What about Adrian Washington? Is that going to be your case? Position 7? I'm sorry, number 7.
Is Adrian Washington here?
I don't know.
I have a note that was a do not qualify first appearance, but that was way back. in
Okay.
2019, so I'm happy.
Oh, who knows? We'll see. We'll call that later. Number 8. Oh, that's the one we're talking about. You're going to break the news to him that there's a felony in the mix. Okay. How about Carla Williams? Not here yet. Is position 11, is that private counsel?
He is here. I haven't spoken with him.
Okay. Mr. Hippensteel? Hey, is Mr. Doherty, is that a lawyer you've hired? Okay. Position 12, will that be yours?
I will double check. For some reason, I wrote Brian Tevis.
Okay.
In this case, but I will confirm that.
All right. Well, like I said, we're getting a little ahead of ourselves. I think we've covered what we can. So I am going to go get some work done until we get Mr. Wright, or it gets a little closer to 11, and then we'll do the rest of the clean arraignment calendar. All right. So yes, you were correct about Mr. Tevis, number 12. He filed a waiver. So waive and schedule. All right. So 12 is taken care of.
For the bond hearing. I can ask her.
Well, that wasn't much of a work break. All right. Mr. Wright, how are you?
I am well, Judge. Thank you for asking.
Good. I'm going to get you and Mr. Adams on the screen here. Mr. Adams shared with me that you are now part of the Anthony O'Neill team.
Yes, Your Honor. I was originally his attorney way back before indictment. And then, of course, I went on that medical leave for quite some time. But I've reconnected and I'm going to be part of the team. And hopefully, maybe we can find a resolution and solution to this.
Great. Okay. Well, let's bring Mr. O'Neill out and we can talk about bond. And then Mr. Jordan, who is probably the fourth prosecutor on this case, it's not a new case, can connect with you and Mr. Adams to see what might be done short of trial. Otherwise, I am as anxious as probably Mr. O'Neill and his family are to get Mr. O'Neill before a jury so we can get closure if that's how it needs to go.
Understood.
Let's add, there's Mr. O'Neill. All right. Ms. Rivers, are you ready to get back on the record?
I'm ready.
Great. Okay. This is case 19 SC 172809, State versus Anthony O'Neill. Mr. O'Neill is here in court. He has two lawyers online, Mr. Adams and Mr. Wright. This is a return for Mr. Wright. He worked on this case long ago. Mr. O'Neill has had several attorneys representing him throughout this lengthy process. And we're going to talk about bond. Mr. Jordan is here for the state. I'm going to open it up to either Mr. Wright or Mr. Adams, or you can tag team it. Just make it real clear who's going to be talking when so that Ms. Rivers can follow it all.
Okay, I can give an opening, Your Honor.
Okay.
Go ahead.
Yes, Your Honor, this was emergency bond request. Since I've been on the case, Mr. O'Neill's been in Grady Hospital at least 4 times, maybe more. He's had some kind of condition that Grady is not able to treat. And of course, the jail can't. So for that reason, we filed emergency bond. I'd like Mr. Wright to take over from now.
Okay. Thank you for that overview.
Well, Your Honor, I would indicate that the court has seen this case has been going for some time. When my client first actually came into custody, he had a severe leg injury as a result of the crash, we'll say the vehicle collision, which occurred in this case. So suffering through even from the beginning of his stay in Fulton County, which has now been a substantial period of time. He has always had some medical issues. Since that, there's been a stabbing, there's been other medical issues which have caused him to have to go to Grady and to be treated. So his stay in Fulton has not been what we would customarily think of jail being. It has been quite the hardship. Ultimately, he is born and raised. He's from Atlanta. All of his family is here in Atlanta. I believe he may have some of his family. Miss Wisdom may actually be in the courtroom or on the Zoom in attendance in support of Mr. O'Neill. So
there are three people here, at least three people who I think are here on behalf of Mr. O'Neill, and we can figure out who they are in a little bit. But you're right, there is family support here.
So you have contacts and sufficient, I guess you say, roots within the community that you don't have to worry about Mr. O'Neill being a flight risk. Two, in all the time that this case has been pending, there's never been an instance that I've heard the state complain that he's tried to influence witnesses or do anything inappropriately as this case has been moving forward. So at least two of the four bond criteria immediately, I think, fall in favor of Mr. O'Neill. He's not a danger of committing any other crimes, and I think the court can give conditions which assure the court with an ankle monitor, maybe even house arrest. You can be sure that he is where he is, when he is where he's supposed to be, and those restrictions will be just fine. But at least if he's under house arrest, we can get him back and forth to Grady or whatever other medical care that he needs to facilitate making sure that his health is at least not being compromised by his custody. So for those reasons, Judge, we think that if the court would reconsider bond based on, one, the passing of time that he has been in custody, but also because of his medical conditions, that you fashion a bond releasing him under any conditions the court feels are appropriate, so that we can tend to his medical care. And I'm supremely confident we're going to have this case worked out, hopefully in the near future. At this point, the amount of custody he's done, I think, will go a long ways towards putting him in a position where he can have satisfied the custodial component. And if the court ultimately agrees and accepts a resolution along the lines of what we're hoping, then at that point, he would be forward-looking more in a probation posture as opposed to a custodial posture.
Am I misremembering when I think that Mr. O'Neill, a chunk of the time that has passed from indictment till now, Mr. O'Neill actually was in the Department of Corrections custody? There was a revocation or some other case, or is he?
There was some time that he did go into corrections and then came back. And I think that may have been a violation based on this case. So I think it still, to that extent, relates to this case.
Okay, I'm not suggesting he wouldn't get credit for time. That's not, we're not at that point right now. I'm just trying to recreate in my head why it has taken so long to get Mr. O'Neill to trial. One reason is that he has powered through attorneys. He either doesn't like their advice or doesn't get along with them. I'm glad to see Mr. Wright's back in the mix, but I know that Mr. O'Neill has had a number of lawyers, and I've been told a number of times we're close to working this case out, and then Mr. O'Neill decides otherwise. But it also, I was remembering, and you've confirmed that there was some time when moving Mr. O'Neill's case forward was going to be complicated because he was serving time for some other case, maybe in connection with this, like you said, a revocation, but he was with the Department of Corrections. That's clearly over with because he's here in the blue jumpsuit and in Fulton County custody. Okay. Mr. Jordan, what do you want to share with me?
Your Honor, I believe that Your Honor is familiar with this case, given that it's had, I believe, at least 2 prior bond hearings, and it has been denied previously for 2 out of the 4 Ayala factors, being that Mr. O'Neill is a risk to reoffend and also a danger to the community. I won't delve too much into the facts because I do believe that Your Honor is familiar with the case, but of course, the leg injury that Mr. O'Neill sustained as he came into the jail was as a result of him getting into a car accident in the stolen vehicle that was—
It's like a white van or something.
That was hijacked, yes, Your Honor, at the Chevron gas station. The state would still maintain that Mr. O'Neill, given the severity of these charges, is a danger to the community, being that the particular carjacking was 2 vehicles, 1 vehicle that was attempted to carjack, but Mr. O'Neill was not able to get the keys to that particular vehicle, then went to a second vehicle and a second individual and carjacked that individual, and of course got into an accident in which several minors and an entire family was hurt as a result of that car accident. Your Honor, he also has previous burglary conviction, with the most recent conviction coming from Cobb County. It has a sentencing date of September 24th of 2020. He has a previous robbery as well. Your Honor, the state would maintain that Mr. O'Neill is a risk to reoffend given his criminal history, and also is still a danger to the community given the severity of the particular charges that he is facing. I understand that Mr. O'Neill in this case have been around for a while, but he does have the upcoming June 7th, I believe, trial date. So the state is ready to proceed forward. But I have been in contact with Mr. Adams. I apologize, Mr. Adams, I wasn't avoiding you. I know you've been trying to reach out to me in regards to this case. And I know Your Honor has heard before that we're close to a plea, but I do believe that we are negotiating, and we very much want to give some closure to everyone involved in this case, Your Honor.
Okay. Let me ask a couple questions of some other folks. Ms. Jackson, good morning, from Pretrial Services. Could you share with me how many cycles Mr. O'Neill has?
Yes, good morning, Your Honor. The defendant has 14 cycles. The defendant's last arrest was June the 3rd, 2018 in Marietta, Georgia, for a parole violation and burglary, smash and grab.
All right, thank you. And I do want to recognize that there is family here. You all don't need to say anything other than, are all 3 of you here for Mr. O'Neill? And how are you connected to Mr. O'Neill? Okay, fiance is here, cousin,
And I'm his sister.
and sister. Okay. Thank you for being here. All right, Mr. Wright or Mr. Adams, anything you want to say in closing?
Mr. Adams, I mean, Your Honor, I would just, again, based on the length of time that's transpired, but also more importantly, because of the ongoing medical concerns of wanting to make sure we can get him to providers, make sure that at least his medical or his health condition doesn't deteriorate. Even again, a very strict house arrest, ankle monitor situation where he may not be able to work, he may not enjoy the freedom of movement, but at least we can facilitate making sure that his condition does not get any worse, and hopefully more so, hopefully we can get him treatment and moving towards recovery from his injuries, or rather his conditions.
Okay. So here's what I'm going to do. For now, I'm going to maintain the status quo, partly because we've got a trial calendar date that I'm going to make pretty firm for Mr. O'Neill, and that is less than a month away. He will be one of the oldest cases on that trial calendar, so I will prioritize it. And I think that's the way to get closure. If Mr. O'Neill wants a trial, let's get 12 jurors in here and let them hear about the evidence in the case. if in fact he's ready to work it out. He's now got not one, but two lawyers working on his behalf. And they know who to contact. That's Mr. Jordan. Mr. Jordan will be reaching back out to Mr. Adams, and maybe it'll be a conference call. We'll get Mr. Wright in there as well. One caveat, we have, and I respect the privacy rights that are at issue here. We have been referring to medical conditions, and I don't want in this very public setting for anyone to have to provide more, but I am going to invite Mr. Wright and Mr. Adams to provide to me for in-camera review what the medical concerns are. I can't make a sufficiently informed decision about the risk in which Mr. O'Neill finds himself because of his inability to get regular routine attention for whatever the situation is, whether it's the leg injury that still hasn't healed or something more. And I get the sense that it's something more, and we don't need to dive into it right now, but I don't want to be ignorant of it. So if you all will get to Ms. Nelson that information, if it's something that rises to the level that I think I'm going to change things, I will loop Mr. Jordan in. I won't make a snap decision. But the good news is, in the meantime, while you're getting me those materials and I'm reviewing them, we're only getting closer to June 7th, which is when we can get a jury to decide the case if it's not otherwise worked out. Okay? Any questions about that, Mr. Wright or Mr. Adams?
No, Your Honor. Well, I'll get that to Ms. Nelson ASAP.
Okay, sounds good. Mr. Jordan, anything else?
And Your Honor, I know Mr. Adams has my contact information, but Mr. Adams, if you can send that to Mr. Wright, I think you may have my number as well, but just give me a call on this one. Okay.
Okay, good. So you all be in touch with Mr. Jordan. If you reach a resolution, even if it is non-negotiated, but it's got the ranges that make people comfortable, let Ms. Nelson know there's no need for us to wait for the trial date. If you all get to a point where Mr. O'Neill says, look, I want to resolve this by way of a plea, we can fit that in any day, consistent with your schedules. I think the hangup will be lining up Mr. Adams and Mr. Wright, but we'll work around your schedules to make that happen if that's where this is trending. Okay?
Understood.
Mr. O'Neill, you've been very quiet. Your lawyers have been doing the talking. Do you have any questions for me about what we just discussed?
So you're saying that in between now and the trial date, that they can come back with the medical papers and stuff?
They're going to send me those medical papers. I'll look at them. That's going to stay private. But if I get concerned that we need to do something different, then I'll do something different. Always with an eye to, well, June 7th is coming up. And so do we really want to upset the apple cart? Because we know right where you are and can get you to court. I can guarantee you'll come to court for your trial where you are right now. And that gives me comfort. But if there's a medical situation going on that we ought to be addressing in a different way, that would take priority. So I will look at the material that your lawyers send to me. And if we need to do something different, I'll make sure that happens. Okay. All right. Thank you, everyone.
All right. Judge, may I be excused?
Yes, sir. And you too, Mr. Adams.
Thank you, y'all.
All right. Thank you, Judge.
Mr. Jordan, I know that this June trial calendar is post-transition, but you should let Mr. Peoples know that I won't be continuing the O'Neill case at the state's request. That is why I know that there are a bunch of witnesses. I'm very familiar with the facts. Actually, I had a bond hearing with Mr. Wright as the defense attorney when I learned a whole lot about the leg injury and, more alarming, the injuries to the people who were hit as Mr. O'Neill and his co-defendant were trying to get away. So there are a bunch of moving parts, but that's one that ought to be prioritized if it's not going to work out before then.
I believe that we'll have it worked out before then, Your Honor.
Okay.
I've been in contact with Mr. Adams a lot, so I believe that we're pretty close.
Excellent. Let's turn to our plea and arraignment calendar. Position 1 is Charles Lynn Brown, and I apologize if I didn't get the first name right. Oh, she's in custody. All right. I don't see Mr. It's you. Great. It's Ms. Willingham. Can we bring Ms. Brown out, please? Of course it's you.
Because why wouldn't it be, Judge?
Right. The least busy lawyer in the DA's office. Is this also an arraignment or just a bond hearing?
I think she's already been arraigned, Judge.
Okay.
I'll double check that.
Well, I'll look while you're having that conversation.
Miss Wood, is your microphone on?
Which microphone?
It's counsel. Miss Wood.
It's on now.
Okay, thank you.
Sure. All right, let's get on the record in Ms. Brown's case. It's 23 SC 185873. And Ms. Brown is here in court with her lawyer, Ms. Wood. We are working through a bond motion. Ms. Brown is charged in this case with involuntary manslaughter, allegedly causing the death of Michael Boyd, and aggravated assault with a deadly weapon, possession of a firearm during commission of a felony, and reckless conduct. Ms. Brown has already waived arraignment. That happened back in February. And we are going to, and it looks like discovery's been flowing, which is all good. And we're going to talk about bond. I think in January of this year, bond was denied by Judge Carnesale. No, maybe the charges were a little different then, which is why it would have been in front of Judge Carnesale. But here we are. Ms. Wood, share with me, please, why you think Ms. Brown should get a bond and what that bond should look like.
Thank you, Judge. Ms. Brown is 22 years old. She is a lifelong Atlanta resident. She has 2 children, ages 2 and 4. They are currently living with her mother. Her mother could not be here today because her mother was recently in a car accident, has some broken bones, so she's really having a hard time taking care of the babies and also recovering. Ms. Brown's sister Tyronda is here present in court. She traveled here from out of state, so we do appreciate her being here on behalf of Ms. Brown. Ms. Brown has a good address to return to, Judge. She can live with her parents at 651 Gales Court. That is in Atlanta. It's in the South Fulton area.
Can you say the name of the street again?
It's 651 Gales Court.
Oh, yes.
Gales?
Yes.
How do you spell that?
Gayles.
Okay.
Judge, she has.
And when you say live with her parents, I heard you talk about mom and kids are with mom. Who else is in that household?
I think it's just mom, dad, and the kids, but
Sister, little
There's-
sister.
there's a younger sister there apparently.
and
Okay.
brothers. It's like sister, little brother, and an older brother.
Okay, older than you.
Yes.
Okay, so it would live with parent. Dad doesn't live there, or you could also live with your dad. I just want to make sure I'm understanding the options.
Yes, my dad lives there too.
He lives there too. Okay, no one had said that. So there are a number of adults in the house. Your brother, older than you, would be an adult. He may not act like it, but he's an adult. But your mom and dad both live there.
Right.
Okay, got it. And then your kids, so it's 3 generations, grandparents, and then you and your kids. And then you've got some siblings there.
Right.
Got it. Okay.
Judge, she does have, she did not finish high school, but she's working on her GED at Atlanta Tech. She was gainfully employed before being arrested at Sensational Subs near the Georgia State campus. She's indicated she can return to work there. She's also previously worked at Burger King. She has some other service industry experience. So I want to let the court know about that. Judge, this is a tragic situation. The victim in this case was her partner. I'm sure the state has a different perspective. I don't know how else to say it, except that it's a tragic accident.
She's been in custody 190 days, no bond. She doesn't have a criminal history. We're asking the court to consider a $40,000 bond on this case. She has no issue with an ankle monitor, a curfew. She just wants to get out and get back to her babies. And as I said, she hasn't even really had a chance to grieve, to process what happened in this situation. And so we're just asking the court to consider setting a reasonable bond of $40,000.
Was Mr. Boyd the parent of either child?
Both, yes.
Both. Were you living at Gales Court when this happened?
No.
You and Mr. Boyd had your own household?
Right.
And were your children living there also?
Right.
Okay. Ms. Jackson, do you have any criminal history information for Ms. Brown?
She does not have a prior arrest file, Your Honor.
Thank you. All right, Ms. Willingham.
Your Honor, I'll start by my communications with the family in this case.
When you say family, meaning Mr. Boyd's family?
Yes.
Okay.
I have spoken with Mr. Boyd's sister, Mary Boyd, and I believe she's supposed to be present today. I'm not sure whether she has appeared in court or I don't see her on the Zoom. What I will say though, in my communications with her, she actually would not support the state arguing for Ms. Brown to stay in custody. She would probably echo much of what Ms. Woods just represented to the court. I have also had the opportunity to speak with Mr. Boyd's daughter, and she would just defer to the court in this instance.
Mr. Boyd has a daughter.
Older daughter.
Through another mother.
Correct.
Okay, but old enough to have processed this situation and have a perspective on it.
Correct.
Okay.
And she would just defer to the court in this matter. So I want to make sure that I didn't want to forget to acknowledge their sentiments.
No, that's very important. I was going to ask you about that anyway, but it's wise to lead with that rather than try to bury it underneath. Ms. Brown needs to be in jail forever.
Yes. And now with that said, as to the facts of this case, the state would argue that the conduct in this instance rose to the level of being reckless because Ms. Brown did pull out a firearm towards one of Mr. Boyd's other children, who is also older. In fact, in her communications with law enforcement, she stated that the reason that she put the clip in the firearm was because she did consider actually using it on Mr. Boyd's son. We would not argue that altercation with the son then ended, but we would state that Ms. Brown did take the safety off because, again, she was taking steps to move forward with shooting Mr. Boyd's son. And ultimately, her conduct became reckless because she did not put that safety back on. And that is how Mr. Boyd ultimately was killed. I recognize that the family would not agree with the state asking for Ms. Brown to stay in custody. And ultimately, we would also defer to the court. What we would ask is, I don't think we're too far apart, but what the state would be asking, if the court did place a bond on this case, we would ask for $50,000.
Okay. Have you had a chance to speak with Mr. Boyd's son, who was involved in whatever disagreement, altercation, whatever we want to call it, alleged between Ms. Brown and that son?
We did not, Your Honor. I know law enforcement did. We have attempted to reach out to him.
Is he an adult? Was he? Okay.
He is, and we've tried to reach out to him by way.
How old was Mr. Boyd? Ballpark.
Older judge.
Yes.
40s? He was in his 50s, Judge.
Okay, got it.
That is correct, Your Honor. And
Which isn't old, just so we're clear.
we agreed.
It's a good
Agreed,
age.
Your Honor.
All right, but I just, I
Agreed.
was thinking otherwise,
Based on
given,
the older children that I'm acknowledging, yes, Judge.
Okay.
And we have not had an opportunity to speak with the son. We have made ample attempts to reach out to him, both directly as well as through his aunt and his siblings. We have not been able to speak with him yet. In his communications with law enforcement, I will say that he does not give his description of what happened that day is not drastically different from what Ms. Brown represented. I think what he would represent, though, is that Ms. Brown did pull out the gun and that she did come towards him with that firearm. And based on that is why the state would still have some concerns.
okay. Well, everyone should have concerns based just on what happened here. The question is whether Ms. Brown should be out on bond or not, pending disposition of her charges. Tragic, they're serious, and we need to be mindful of all that. Ms. Brown, does your father work?
No.
I know your mother's injured right now because of the accident. Does she work when she's healthy, when her doesn't have broken bones?
She's a caregiver to my brother. Like I said, he's living with my mom. So she's a caregiver to him because he's schizophrenic. So
This is your older brother?
he's one of my older brothers, yes.
How many older brothers live in the Gales Court household? Just one. And that's the one your mother cares for?
Yes.
Okay. Is your father retired or he's just not working?
He's just not working.
Okay. How does the household generate income?
Just from my mom, I guess getting the money from, my brother.
Okay. The disability benefits for your brother.
Right.
Okay. And then you've got some younger siblings. Are they school age?
Right. They're in school.
Okay. And then your kids are there.
Right.
Okay. Is there room for you?
Yes.
Okay. Do you know if there are any firearms in that household?
There are.
Okay. All right. Ms. Wood, anything you want to add?
No, well, just very briefly, I do believe that as this case progresses, I think there was maybe some feelings from Mr. Boyd's older children due to the age difference. And so I don't know if that's going to come out in discovery, if there were things that happened.
It sounds like a complicated dynamic.
Yes.
That became clearer as I understood who was what age. Okay.
Yes.
Ms. Brown, I do think that setting a bond is appropriate in this case. You've no criminal history. It sounds like nothing like this, fortunately, has happened in your life or those immediately around you, other than this one Halloween incident. I will set it at $50,000. It'll be through the sheriff's 10% program, which means the money that your family puts up, they'll get most of it back when the case is resolved. You'll be subject to pre-trial supervision. We'll start that at level 2. I don't really know the value of an ankle monitor. We can do that, Ms. Willingham, but I don't see Ms. Brown as a flight risk. Her kids are here. I guess why don't we start out with one for a few months and see how that goes. It'll be funded by the county. So when you get back to work, which you need to, that can go towards supporting your household and not paying for the ankle monitor. So we'll start out with an ankle monitor. If for some reason this case doesn't move quickly, then Ms. Wood, I invite you to file a motion for bond modification if we get into late summer, early fall, and we're just treading water and there've been no issues with Ms. Brown on bond, assuming she makes the bond, we can get the ankle monitor removed. And for now, we'll start out with a 8 p.m. to 8 a.m. curfew. Again, I don't know that that really fits, but if you find work, we'll switch that curfew around. If your job is from 4 in the evening to midnight, we'll move the curfew so you can work that 4 p.m. to midnight shift if that's what you find. But I do encourage you to get back, whether it's Sensational Subs or somewhere else. And then obviously, no guns in the house. That'll be a special condition of your bond. So if something changes and your parents say it's not safe out there anymore, we need a gun, they can't if they want you to be living with them. No firearms in the household. What about contact with the Boyd family? I don't know if they are going to want to see the kids. I don't want it to be awkward. It sounds like they aren't worried about Ms. Brown, but if they want to process this on their own without Ms. Brown appearing in their lives.
The children, I believe, feel that way. However, I do anticipate that the victim's sister, Miss Mary Boyd, she has expressed that she does wish to still have a relationship with Miss Brown's children.
So why don't you, I'm sorry to interrupt you, but if you would get it to Ms. Nelson, the names of Mr. Brown's adult children who don't want any contact. I'm sorry, Mr. Boyd's adult children who don't want any contact with Ms. Brown, and then that'll be a condition of your bond. I'm making the name up, but Fred Boyd, you can't reach out and say, I'm so sorry about what happened, or why are you need to, Ms. Wood may want to talk with them, but you can't. But it does sound like Mr. Boyd's sister does want to stay active in, I guess it would be her nephew and niece. I don't know what gender they are, but your kids. Yeah. So if you'll get those names to Ms. Nelson.
Yes, Your Honor.
Okay. Any other conditions you were thinking of?
No.
Okay. Ms. Wood?
No, Your Honor. Thank you.
You'll be required, Ms. Brown, to reside at 651 Gales Court. What city is that in?
I think it has an Atlanta zip code. One moment. Yes, 30354.
All right. So you'll be required to live there. If for some reason you need to move or want to move, that's a possibility, but you need to arrange that through pretrial services. They have to approve of the new address. So I'm making it up, but you can go live with your sister. You need to get the green light, obviously, from your sister, but pretrial services would need to say that's okay. Your sister doesn't live in Georgia, so that wouldn't be an okay place for you to be. You'd need to be local. For now, that will be the Gales Court address. Okay. Any questions about any of that?
I was just wondering about my phone situation. They took it at College Park, and my mom went to go get my purse from College Park. Well, they sent it to I don't see it in evidence. I don't know if it's still there.
So that's a good question for Ms. Wood. She'll help you navigate that. It may be that the state views it as evidence in this case, in which case you're not getting it back right away. It may be that the way this case played out, your phone isn't going to be of interest, and so it could be released. But Ms. Wood can explore that for you. Okay.
Okay.
All right. And so Ms. Nelson can structure the bond. It'll be $25,000 for count 1, $10,000 each for counts 2 and 3, and $5,000 for count 4. That gets us to $50,000.
Thank you, Judge.
You're welcome. And thank you, Ms. Willingham, for your thoughts about this case and sharing what Mr. Boyd's sister at least had to say.
Thank you, Your Honor.
All right, plea and arraignment. Reginald Hughes. I've got a booking number for him. So is Mr. Hughes in custody?
Yes, he's in custody.
Okay, we'll get him brought out. Well, while we're waiting on that, is John Kilgore here? All our PDs ran away. Let's keep pressing on. How about Morgan Villa? Ms. Nelson, did Mr. Melnick waive arraignment for Morgan Villa?
Yes, he did.
Okay, then we're set.
This is 4, 7.
Charlie Neal's here? Oh, hey, Mr. Neal, your lawyer will pop out in a minute. I think she already filed a waiver. Ms. Wood, do you represent Charlie Neal?
Yes.
Position 4?
Yes.
Mr. Neal's right there. So I was just letting him know, you guys can connect, but then when Ms. Wood says you can go, okay? So just sit tight for her. All right, let's do Mr. Muhammad's case because I see him here. That's assuming his client is, oh, he is, Mr. Russell. Great. Now this is Ms. Hall's case. Will one of you cover Mr. Jordan? I think you said you would.
Yes.
Okay. Come on up, Mr. Russell.
We will formal reading.
Okay, so you're gonna waive arraignment for Mr. Russell. We'll get a scheduling order entered. There's a waiver of arraignment form that you and Mr. Russell should fill out. Let me make sure we've got good contact info for him in our system, Mr. Muhammad. And then assuming everything checks out, I'll enter a scheduling order, which will trigger Ms. Hall, who's not here today, her obligation to get you discovery. You'll have a motions deadline that is after the delivery of all that discovery, and we'll move the case along. Let me see what we got here. Mr. Russell, do you live on Dogwood Drive?
Yes, 126 Dogwood Drive.
Right, apartment 45?
Yes, sir.
Good. All right, we've got the right address for you. Your lawyer is going to fill out that waiver of arraignment form. When he's done with that, anything from the state? No. Okay. Once Mr. Muhammad has filled out that form and gets it to me, you're good to go. You'll get notice for your next court appearance.
All right, thank you.
Sure.
I need to borrow it, actually.
Okay. That looks pretty fancy. Make sure you return it. Mr. Russell, let me look at one other thing. So you are staying away from Ms. Williams and you are living with Ms. Freeman?
Yes.
Great. I just looking at the conditions of your bond. That was a while ago. That was almost 2 years ago, but they still apply. Mr. Muhammad, if there's a reason to modify those, is the guy to reach out to, and then he can petition me to change things. I don't know if you're still wearing the ankle monitor. It may be time for that to come off if we've gotten 2 years into things, but that would need to hear from the state, all that. I didn't realize how old the allegations were here. Want to make sure you were doing what you need to do and can comply with the bond. Okay?
Yes, sir.
Thank you. So Adrian Washington, you're here. Great. It was a direct indictment. So how'd you know to be here?
I got a letter.
You got a letter?
Yes, sir.
Fantastic. Ms. Feely, are you representing Mr. Washington, or was this the one where you said it didn't look like he qualified?
I'm going to speak with them now.
Okay, great. I'm gonna have you talk with Ms. Feely, and she's gonna figure out whether you qualify for appointed counsel or if you'll need to hire your own attorney. So she'll have a financial conversation with you. If you qualify for appointed counsel, then Ms. Feely will be your lawyer, and we'll move forward with your case today. So I'm gonna ask you to talk with her, and then so I'll circle back with her. So please don't leave, okay? All right. Yes, sir. Thank you. All right, Brandon Harris.
He is here. This is the one I've been speaking with.
Yep.
I haven't filed a waiver yet because we're trying to see if we can get this worked out today.
Okay.
So if we can continue those discussions.
Sure. So Mr. Harris, I guess you got the bad news that there is a felony in here. I know for a little bit, Ms. Feely was thinking, wait a minute, these are all misdemeanors, in which case you should be a few floors down. But the way count one is charged, it's a felony. The allegation was that you were going more than 20 miles an hour over the speed limit when you were allegedly trying to get away from the state trooper. That makes it a felony. So Ms. Feely is going to be talking with Mr. Jordan, the prosecutor. You should sit tight. Maybe the case sorts out today. If not, we'll get a scheduling order in place and move it along, okay? All right. Carla Williams. Oops, that's not the button I wanted. Also a direct indictment from 2020. Do you have information? Yeah, oh, now that Ms. Willingham is here, yes. I don't know why we skipped that. Okay, yep.
And Your Honor, that's actually my case. Ms. Williams flagged that for me, and it's actually a trial.
Okay. And who has Mr. Hughes from the public defender?
That will be mine.
All right.
He's got these two new cases. Yeah, so he's.
Adrian Washington. So that's Mr. Shapiro's case, but Mr. Jordan can cover, is what I heard. Okay. So I see there's already a waiver filed, or it was filed today. So I don't mean to take up a whole lot of Mr. Hughes's time. Mr. Hughes, I'm Judge McBurney.
How's it going?
It's going all right. How's it going for you?
Hopefully better.
Hopefully better. Well, who knows? You are here on an indictment involving alleged conduct from long ago. It's almost 3 years old, but it's a brand new indictment. Ms. Feely has already waived arraignment for you, meaning she's entered a plea of not guilty. I will enter a scheduling order that will prompt Mr. Jordan, gentleman seated there, to get discovery to Ms. Feely. And that will get the case moving along. She'll file motions on your behalf if she thinks that's appropriate. And she'll also start working with Mr. Jordan to see if this is a case that can be resolved short of trial. My goal is to get you a resolution soon, either a trial, we get jurors in here and they hear whatever the evidence may or may not be. But oftentimes cases resolve short of trial, and that's where Ms. Feely comes in. So she'll be working with you. You're at Cobb County, but that's just an outsourcing from us. You don't have a case in Cobb County, is that correct?
No, sir, no.
This is your one case?
Yes, sir.
Okay, all right. Ms. Feely, anything on behalf of Mr. Hughes?
Nothing further.
Okay, all right, Mr. Hughes, we will see you soon. Actually, we'll see you soon as Ms. Feely. All right, so there's no Carla Williams. Is that going to be a bench warrant, Mr. Jordan?
Yes, Your Honor, the state will request the bench warrant.
Okay. That gets us to Mr. Hippensteel.
Good morning, Your Honor. Daniel Darty appearing with Mr. Hippensteel. We had filed a waiver of arraignment back in 2021. Medical circumstances, we were hoping to be able to retry and possibly enter a plea if necessary.
All right, let me look up how there was a waiver of arraignment in 2021. We'll probably need you to fill out a new one, but I've got one here because back then, Mr. Hippensteel had not been indicted. And I just don't want there to be some argument down the road. Well, you can't waive something that hasn't actually occurred yet. But I've got a form right there you can fill out. Mr. Jordan, are you in a position to chat with Mr. Doherty about the situation?
I believe so, Your Honor, because this is a incident where it's alleged that all of the victims are officers. So I can definitely speak and see if we can get this closed today.
Great. So, Mr. Doherty, you fill out that form, get it to Deputy Gordon, who's the deputy with his back to you. I'll get that filed. That'll get a scheduling order in place, but I'm all for if we can resolve it today, that's great. I need to step off the bench in about 15 minutes to go collect my kid, bring him down here. So we're gonna have to take a lunch break, but then I'll be back and there's no reason we can't address this after lunch. We wouldn't be able to get all the way through a plea if it was gonna be a plea before I need to go. So I just want you all to know that basically there'll be lunch break until about 12:45. Okay, that's Hippensteel. How about Dexter McGriff? I'm hoping he waived. They're not here. Let's look. So actually his lawyer is trying to get off the case and we have no Mr. McGriff on some pretty serious charges. Okay. So I guess you're Ms. Hall for today. Bench warrant for Mr. McGriff?
Yes, on behalf of Ms. Hall, they will request it.
Okay. I won't address the question of representation until we've got Mr. McGriff, but Mr. Smith is trying to roll off the case. All right, so if we review the calendar, did we ever get John Kilgore? Or was that one where someone had waived?
We'll stay with requested bench warrant for Mr. Kilgore, Your Honor.
Okay, it's not a direct indictment. It's not all that old. We'll do bench warrant. So Mr. Washington, is your office going to be able to represent Mr. Washington?
Yes, Judge, and I'm working on getting a waiver of arraignment filed right now.
Great, okay. Is that all we'll be doing with Mr. Washington's case today?
I believe so, Judge, yes.
Got it. So Mr. Washington, when Ms. Wood says it's okay to go, you're free to go. Let me make sure we've got some of these cases aged a bit before they were indicted. I want to make sure we've got good contact information for you in the system. You want to make sure you've got real good contact information for Ms. Wood. I've got you in Union City on Oakland Road. Great, okay. And you got something, you told me you got a letter in the mail to be here. That's how you'll get official notice to come back to court whenever that is. Ms. Wood will be letting you know that as well, but we'll be sending official notices to that Oakley Road address. And when Ms. Wood, she's filling out some paperwork on your behalf. When she's done with that, tells you to go, that you may go, you're free to go. Sure. Okay. All right.
Thank you, Judge.
You bet. And then Mr. Harris, Ms. Feely, you're gonna talk with Mr. Jordan about that.
We've been emailing back and forth. I think we're pretty close.
Okay. So that's a possible resolution. Hippensteel is a possible resolution, and that's what's left. So I'm gonna go now. I can be back sooner that way. I'll go get the little guy. If you all want to be back at 12:45, is our calendar at 1? It's not until 1:30. So if you want to be back, is 12:45 too soon? You want to say 1 o'clock? What works best?
That works with, 12:45 works with me, Your Honor.
Okay, and I guess they're both yours,
Yes.
okay, so if you want to be back at 12:45, we'll see what we might be doing with Mr. Hippensteel's case as well as Mr. Harris's. And then at 1:30, it sounds like Ms. McCauley will be covering in the Stanley Porter Pro Se extravaganza.
I just wanted to put on the court's radar, if, I think what I'm asking for, Mr. Jordan may not be able to do today, and in which case I'll file a waiver, but I think this will be a plea soon.
Okay,
Not
great. So if you hit that administrative wall, obviously you can release Mr. Harris. You can just let Ms. Nelson know. You don't need to tell me face to face at 12:45, but if it's something that can sort out today, all the better. Yes, ma'am.
Judge, I am literally typing the email for Ms. Nelson now, but I did want to just let you know in court that I have received communication from my victim witness advocate that actually the children are fine also with Ms. Brown reaching out to them. They just will not make contact with her, but they
Got it.
don't have any issue with her
Okay,
reaching out to
so
them.
there's really no contact provisions in Ms. Brown's bond.
Correct.
Okay, thank you. Got it. All right, well, I will mute the system in here and we'll reconvene at close to 12:45 as I can make. All right. Ms. Rivers, can you hear us from court?
Yes, I can, Judge.
Great. Welcome back. Good afternoon. I think we're going to take a plea in Mr. Harris's case. Is that correct? Before we do that and get on the record, I don't see Daughtery and Hippensteel. That's going to be another day.
Yes, Your Honor, we're close on that one, and they're looking, we were discussing adult diversion, but we may ultimately end up in a misdemeanor plea for that case, but I would need approval prior to that plea.
Got it. So Mr. Daughtery filled out the waiver of arraignment. We'll do a scheduling order and it'll flow how it flows. Okay, well then let's turn to position 8, which is 23 SC 186976, State versus Brandon Harris. Mr. Harris, come on up to the podium, please. And let me get your case on my screen. There it is. Okay. You are indicted in 23 SC 186976. You are charged with 1 felony, at least in the indictment, and 3 misdemeanors. Ms. Feely, is this a negotiated plea?
Yes.
Mr. Jordan, is it to the counts as charged?
It is not, Your Honor. The state will move to dismiss counts 1 and 3 in exchange for a plea to counts 2 and 4. And the state would move to amend count 4 from hit and run to failure to report an accident, which is 40-6-273.
40-6-273.
I believe so. Is that correct, Ms. Feely?
Thank you.
Okay, got it. So Mr. Harris, you are here today to enter a misdemeanor plea, 2 misdemeanors, reckless driving and failure to report an accident. Is that your understanding?
Yes, sir.
Okay. Mr. Jordan's going to put you under oath in just a moment. And then he's going to ask you a bunch of questions. I may have some as well. You may have some questions, and it's important that you let Ms. Feely or me know when you've got those questions so we can answer them on the record. I need to be comfortable that you've understood everything that we talked about. And one way I know that is if something happens that you don't understand, you say, wait a minute, I didn't follow that one. Will you do that?
Yes, sir.
Okay, Mr. Jordan.
Thank you. Mr. Harris, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Brandon Harris.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there a medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
I'm 23. I got my GED.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have been charged with the offenses of reckless driving and failure to report an accident?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer, Ms. Feely, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes.
Ms. Feely, do you waive formal reading of the indictment?
We do.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Harris's name?
We do.
Mr. Harris, do you recall having been arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Feely, do you know of any outstanding warrants related to these charges?
I do not.
Mr. Harris, has your attorney advised to you the minimum and maximum sentence for each charge that you are pleading to?
Yes.
And just for the record, Your Honor, these are both misdemeanors, so the minimum is 1 day and the maximum is 12 months in custody. Mr. Harris, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, as previously stated, the state is moving to dismiss counts 1 and 3. I did receive some information from Ms. Feely that the insurance had been handled and had been rectified. And I will explain my rationale for dismissing count one when we reach the plea litany. The state's recommendation as to counts 2 and 4 is 60 days to serve, commuted to time served. I do believe that Mr. Harris may have spent at least 50 plus days in custody in regards to this incident. Those two counts are to run concurrent with each other, and the state would ask for no further probation or supervision. Mr. Harris, was that the negotiated recommendation that was communicated to you?
Yes.
Do you understand that the court does not have to accept that recommendation?
Yes.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes.
Are you currently on probation or parole?
I'm on DeKalb County probation.
Okay. And my understanding, Ms. Feely, is that he has already been revoked for this incident.
So he was actually on parole when he was revoked. I'm messaging now with his public defender in DeKalb. So we don't think that this will revoke him again, but he is on probation in DeKalb.
Okay, we can engage Ms. Tucson on it as well when we get to that point.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a plea of guilty?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Mr. Harris, how do you plead to the charges of reckless driving and failure to report an accident in indictment number 23 SC 186976?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that since these are both misdemeanor charges, which you're entering a plea to, you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
And do you understand you only have 30 days from today to file a direct appeal?
Yes.
And Your Honor, for a factual basis for this case, on October 13th of 2021, an officer from the Georgia State Patrol was stationary on the westbound side of I-20 near Boulevard when he observed a blue Dodge Charger approaching at a high rate of speed. The officer visually estimated the speed to be at 110 miles per hour. He did then confirm with a radar that it was actually 107 miles per hour in a posted 60 mile per hour zone. The officer then pulled out as the vehicle approached and observed the vehicle brake hard, still in the first lane of travel before moving right. The driver then did pass and the officer attempted to initiate a traffic stop. The driver moved to the right shoulder as if he was going to stop. And upon entering the emergency lane, the driver accelerated rapidly and initiated a pursuit. The officer then, or the trooper then notified other troopers about the vehicle pursuit. The driver exited Hill Street recklessly, showing no regard for himself or others. The driver then crossed over I-20 and re-entered the eastbound ramp. During this series of turns, the driver began to lose control of the vehicle. The officer observed an opportunity to end the pursuit by utilizing a pit maneuver. Since the driver had already shown a complete disregard for public safety and the officer knew that traffic conditions were growing heavily eastbound, he attempted the pit maneuver, but was unable to do so. But then he was able to see that Mr. Harris was losing control of the vehicle and was going to crash. He did end up striking a vehicle. The vehicle then came to a complete stop and he did attempt to flee on foot, but he was apprehended. These events did take place in Fulton County, Georgia. Your Honor, there is a crash report which indicates that it was a Chevrolet 1996 vehicle that Mr. Harris did strike, belonging to a Christopher, and that has normal spelling, Wright. We did not receive any restitution requests from Mr. Wright. We actually reached out to the Georgia State Patrol troopers for assistance in being able to locate these individuals, and we did not receive any responses from them. And this is before the case was indicted and after the case was indicted.
When you say locate these individuals, meaning the troopers who were involved or Mr. Wright?
The troopers and Mr. Wright, because the information that's on the crash report is not correct, apparently, for
Okay.
Mr. Wright. So the state did feel comfortable with this. I spoke with Ms. Feely this morning about this case, and it does sound like alongside of the 60 or 50 days that Mr. Harris did serve, he also was revoked a significant amount of time that I'll defer to Ms. Feely on to give an exact amount of time that he was revoked. So given those things, Your Honor, the state would ask that you accept this negotiated plea.
Okay. I'm just looking at the jail records. It does look like there was 51 days in custody back in October onward 2021, which would have been right when this happened. And then another 4 for some reason in August. Maybe that was, well, that wouldn't have been when it was indicted. Anyway, in August of last year. So 55 days.
Excuse me. That's when I came back from down the road.
Okay, so you got violated on parole, did some time, and then were here for a few days before you bonded out.
Mm-hmm.
Got it. Okay. All right. Let me, before we hear from Ms. Feely, hear from Ms. Jackson from pretrial. Good afternoon, Ms. Jackson.
Good afternoon, Judge. The defendant has 8 cycles. The defendant's last arrest was January the 16th, 2023 in DeKalb County for a battery, a misdemeanor. There was no disposition for that arrest. The defendant does appear to be on first offender probation in DeKalb County. It's 3 different cases. One is for theft by receiving stolen property. That disposition date was February the 11th, 2019. The term is for 6 years. And the other one is for robbery and has the same disposition date. The term is for 8 years. And there's another case for criminal damage to property in the 2nd degree, and same disposition date, and the term is for 5 years. That case appeared to be sealed. It was sealed February the 11th, 2019. Nothing in addition, Your Honor.
The first offender disposition for those 3 cases, that was what year? 2019?
2019, Your Honor.
Okay, thank you.
Yes.
All right. So Ms. Feely, this sounds pretty serious, but it also sounds like there were already some consequences for Mr. Harris. Why don't you share those with me?
So as I think you had the same screen I'm looking at here, he was transferred to DOC based on the parole violation that this triggered. So he did, I think, a full year or close to it.
So there would have been a hearing back in DeKalb in connection with somehow he got first offender on 3 different cases. And there was a revocation, not of probation, but of parole in DeKalb.
Right, and we're trying to, been messaging with this public defender there to figure out if they can now revoke him again for the same offense because he's now on probation and it's a conviction.
Okay.
We're hoping Judge Hyder does not do that.
Okay. All right. Okay. Ms. Tucson, how are you doing?
I am well. How's everyone this afternoon?
We're hanging in there. Can you provide any insight as to what happened as a result of these charges in DeKalb?
The three cases that were mentioned are the ones that he is on probation for. So he is on probation in 3 cases.
Right. But are you able to tell if while he was on parole for those 3 cases, if he got revoked and for how long and for what reason?
Yes, I just pulled that up. Looks like it was in 2021. Georgia State of Board paroles. Okay, so he did have a parole revocation. I could send this over to Ms. Nelson if you'd like, real quick. But it basically is stating that this revocation order has to do with Fulton County charges. So I would believe it's these, yeah, because it says reckless driving.
Okay.
Things of that nature. I'm sending it over to her right now.
Okay, perfect. And what was the revocation?
Looks like, oh, I'm sorry. I was adding the attachment. Parole, that the above has okay, it keeps talking about he's violated. You're referring to like the time, right?
Yes,
how
ma'am.
Much time was revoked? Yes, I am looking for that. It just keeps talking about how it doesn't say. I'm admitting to the charges. Understanding my parole shall be revoked without a final hearing. I understand that the board will reconsider my case 6 months from the date of my arrest after the pending criminal charges are adjudicated on this revocation. So does that sound like that's the only, I guess, verbiage stating?
Have you, whatever you're reading from, have you sent that to Ms. Nelson?
I just sent it over to her.
Okay.
Yeah, there's a lot of paragraphs in it, but I think it's basically stating it's kind of like up in the air until the final disposition of this case happens, is what it sounds like.
Okay. Ms. Nelson doesn't have it yet. I need to read it. So I guess we'll need that to go through.
Okay, she should have it. Says sent. Yeah, she should have it. And those 3 cases do have a lot of remaining time on all of them.
Okay. All right, here it is. Okay, so they revoked the rest of your parole. I don't know how much parole you had left, but I guess we can figure that out because it would be until August. So they revoked you in November and then you came back here in August. So that's about 10, 12 months, almost a year. I guess that's what you had said. Okay. 8 and 2. All right. Do you still have the blue Charger?
Yes.
Okay. How badly was it damaged and how badly was the Chevrolet or whatever it was you crashed into?
I can't really, you want a 1 to 10 scale or describe?
Well, like,
it?
were you, I don't know that you drove your car away because they may have pulled you out of the car. Like, was your car drivable after that?
Yes.
How about the other car?
No.
No? Okay. And then you did about a year with the revocation. What are you doing these days? Are you working?
Yes, sir. I do work.
What do you do?
I work at the airport.
What do you fly a plane or do you fix planes? What do you-
Nah, I do like trad, like I'm a janitor type thing.
Okay. Inside the airport?
Yeah.
All right. How long have you been there?
For like a month now.
How'd you get the job?
Do a temp service.
All right. All right. Ms. Feely, anything else on behalf of Mr. Harris?
Yes, briefly, as you heard, he's 23 years old, has his GED, he's single, no children. I'm sure the court is interested in why, when there was no guns or drugs, he wasn't fleeing from a crime, why this happened. And he tells me that he just panicked and was scared.
Because he was on parole.
It was a poor decision in the moment, and he realizes that now. And Mr. Jordan may explain this, but we structured this plea to avoid a license suspension because he does have a valid license now, which enables him to have the stability of transportation to work and stuff. And driving on a suspended license is actually arrestable, so it could compound his issues, and it's also very expensive. I remember from being in traffic court. So we are asking the court to accept the plea as negotiated.
Okay. All right. Mr. Harris, do you have any questions about anything we've discussed?
No, not except like, if they gonna violate my probation. Cause I still got other cases, like the case I just caught in the cab for the battery.
Right. So your DeKalb situation is complicated. I think you may still have first offender status on all 3 of those cases. What may cause you problems there would be the battery that you caught. This shouldn't, because I've looked at the parole revocation and you've already had your parole revoked because of these charges. So I think it would be double jeopardy for then DeKalb County to try to tangle with your probation. You are now pleading to a subset of the offenses that prompted you to have your parole revoked. And parole and probation aren't identical, but they're administered by the same agency. So I'd be surprised if there were any consequences for your 3 probation cases because of this plea. Again, that battery that you've got, that's a different ball of wax. That may be, but that's all in DeKalb and the lawyer there can help you with that. Okay?
Yes, sir.
All right. Mr. Harris, I find there's a factual basis for your plea to reckless driving and failure to report an accident. Were you arrested there at the scene of the accident, or did you get away on foot? Or I didn't get quite how it ended.
He was arrested at the scene, Your Honor. I believe that he attempted to flee on foot, but was detained pretty quickly thereafter.
Okay. Got it. All right. Do we know, I know you didn't have any success reaching Mr. Wright, but he didn't need to be medevaced out of there?
No, Your Honor. They didn't report any injuries. I think that the only medical attention was they checked to see if Mr. Harris was okay, and he was cleared.
Okay. All right. So I find there's a factual basis for your plea and that your plea is knowing and voluntary. Knowing means you've understood the things we've talked about. You did ask a question about what's the impact in DeKalb, and I've given you my educated answer, meaning I don't know for sure, but having looked at that's why I wanted to get that document from parole to see what it said. And I don't believe that there ought to be consequences for your DeKalb probation because there were already consequences for your DeKalb parole. And I'm happy to engage the judge in DeKalb about that if we need to. But again, I want to be clear that it's got nothing to do with your new charge in DeKalb. That may bring you trouble with your probation, but that's a different situation. Do you have any other questions besides that?
No, sir.
Okay. And as I said, I find your plea is voluntary, meaning no one's forced you to enter this plea. You've decided that this is how you want to move forward. Do you, Mr. Harris, authorize my staff to sign the indictment indicating your guilty plea to the 2 misdemeanors?
Yes.
Ms. Feely?
Yes, Your Honor.
Mr. Jordan?
Yes, Your Honor.
Okay. All right. I am going to sentence you on count 2 to 50 days in custody, and count 4, which has been reduced to failure to report an accident, which is OCGA 40-6-273, also to 50 days in custody. Those will run concurrently with each other, meaning at the same time, and you will get credit for the 2 blocks of time that we've got in our system that you spent at the county jail. So that's October 13th, 2021 through November 2nd, 2021. And then there's this really the only one we need to focus on because that's 1 day more than 50 days. Okay. Mr. Jordan, anything else in Mr. Harris's case?
Nothing further from the state, Your Honor. Actually, what Ms. Feely stated about the structure to avoid a suspension for Mr. Harris's license is correct, and we factored that in. And of course, factoring in the long amount of time that he was revoked on his parole.
Okay. Ms. Feely, anything else?
No.
All right. Well, thank you for working with Mr. Harris today and sorting this out. Mr. Harris, any questions?
No, sir.
Okay.
Maybe we can start a trend of arraignment, please.
Yeah, go for it. All right. Thank you all.
Thank you.
Hey. Hey.
I'm gonna stick around and watch.
Okay. Yeah. Mr. Porter. Love that.
Yeah, I love a pro se defendant, so I have that other case with Kat, where Kat's my hostage in Barwick.
See you tomorrow, Judge.
All right. Take care. So Ms. Tucson and Ms. Jackson, our hearing this afternoon is not going to result in any pleas. So I appreciate your help with our calendars this morning and this afternoon. And I will see you both sometime soon.
Thank you, Judge. Have a great one.
You too.
All right. Thank you. Have a good one.
Bye-bye. All right, Ms. McCauley, give me 1 second and then we'll look to get Mr. Porter out here.
Yeah, that's fine.
So Ms. McCauley, you are here for Mr. Shapiro just to work through the 414
Yes.
item. Excellent. All right. I'm just printing one thing out in connection with that. I assume Mr. Porter's here?
He's here, but I'm waiting on my.
Your partner?
Yeah.
Okay.
You just know myself. Sorry, just ready?
I need 2 minutes now.
It's 2014 plus. Wait, 21. Oh my God, I might be out of time.
All right, I'm ready. Sorry for the delay. Mr. Shapiro, okay-ish?
He has a temperature.
Uh-oh.
He's probably watching on YouTube, so I probably shouldn't see him.
All right, Ms. Rivers, are you ready for us to go on the record?
Yes, I am.
Great. Let's do that. This is 22 SC 184973, State versus Stanley Porter. Mr. Porter is here. Good afternoon, sir.
How are you?
I'm all right. How are you?
Hey, I'm alive.
You're alive. That's a start. Let's build on that. Mr. Porter is representing himself pursuant to his request and an order I issued documenting his knowing, intelligent, and voluntary election to self-representation. Ms. McCauley is here on behalf of the state. Mr. Shapiro has a conflict, so Ms. McCauley will be handling things for the state. We've got one scheduled item and then an item I want to add just with a question to the state and Mr. Porter. We'll do that first. But the main event is for Ms. McCauley to make her presentation about the 414 evidence that the state seeks to introduce at Mr. Porter's trial. In other words, other acts that involve allegations of child molestation. But before that, I noticed, because I was checking the docket and wanted to make sure I hadn't missed anything for Mr. Porter, that Mr. Porter had filed a request for docket information, something like that, in this case, as well as a 00SC case. It is 00SC 15115, which is a case assigned to Judge Swall. It is old, but it is old in this sense. It was re-indicted, and the re-indicted case was resolved, I think, by way of a guilty plea. Doesn't matter whether it was a trial or guilty plea. There was a final disposition in the superseding indictment for the 00SC case. But it sits open. If you go to that 00SC case, it's open. And in fact, Mr. Armstrong from the state recently filed a motion to null pros the case. And Mr. Porter has filed a motion opposing that, and a motion to dismiss it, and a speedy trial demand, et cetera. I'm not going to get in the middle of that. It's a Judge Schwall case. I don't want us to get distracted by that because it is, I believe, a legal non-event. If we would re-indict cases with the same indictment number, which I'm told we may begin doing starting in 2024 with the new clerk and a tweak to Odyssey, we wouldn't run into this situation when the state says, wait, we are going to re-indict this case. We actually keep the same case number. And then we don't need to worry about this straggler open case that alleges that Mr. Porter committed whatever you're charged with in that case. I think it was aggravated child molestation. The state couldn't move forward on that anyway on grounds of double jeopardy because the newer version of that case was already resolved. So I just flagged that. Mr. Porter, I don't know what Judge Schwall is going to do. It may be that someone from the DA's office needs to bring it to his attention because they just filed something and that doesn't cause a red light to go off in his office. But we in the 22 SC case aren't going to get bogged down any more than what I've just said about the 00 SC case. All right, let's turn to the 414. Ms. McCauley, I've reviewed the pleadings. We just didn't have time to go into them the last time Mr. Shapiro and Mr. Porter were here. There were a bunch of other, I think Mr. Shapiro was here. You may have been covering it. It was you again. This is going to become your case by okay. Nope. Anyway, we worked through a lot of good legal argument from both sides about demurs and really it was a constitutional speedy. I've ruled on all those. Those orders are in. This is the last thing that I need to rule on so that both sides, the state and Mr. Porter, know what is the universe of evidence that is theoretically admissible at trial. And then we need to get Mr. Porter that trial. So I want to work through that. And then Mr. Porter, I'll see if there's anything else you want to talk about. And then we ought to be in a position, once I enter an order on the 414 notice, to get this trial going. So without further ado, Ms. McCauley.
Yes, Your Honor. So I'm aware that the court has reviewed the pleadings that have been filed by the state as it relates to the state's motion. However, I do just want to go over the case in chief and then how that might relate to some of the similar transaction evidence.
Sure. And before you do that, and that's helpful, and you ought to make that record anyway. Mr. Porter, just so you know, and I know you are becoming more and more a student of the law. So I'm not talking down to you in any way. This is more for me to make the record. Under what we call Rule 414, OCGA 24-4-414, the state is empowered to seek to admit at trial evidence of other instances of child molestation, if that's what the case in chief is. Unlike 404B evidence, where there needs to be a proper purpose, and that's a fairly narrow universe. An example would be motive or intent or lack of mistake. So let's say, I'm making this up, in the case in chief, your defense was, sure, I spent time with this young lady. I could have sworn she was 21. So your defense is mistake. I didn't know she was underage. Under 404B, the state could try to get something in and say, well, here's another situation where Mr. Porter was with someone who was underage and he knew this person was underage. So jury, you shouldn't believe the defense of lack of mistake. But the state has to be very specific as to the purpose it's getting it in. Not so with 414. 414 allows the state to admit other acts of, in this case, child molestation for any purpose, to include what is the ultimate prohibited purpose of 404B, where the state would try to argue with a wink and a nod, hey, I know I'm saying lack of mistake, but what I'm really saying, jurors, is he did it before, so he must have done it this time. Propensity evidence. 414 evidence can be used that way. The state can get in front of the jury and say, you heard about what happened in the case involving Ms. Porter, the case involving so-and-so. He did it then. That's evidence that he did it this time. They can argue that. Now, you could be able to argue against it saying that's evidence of nothing. But we don't need to engage in a discussion about, well, what's the purpose for getting it in? I evaluate basically two things. One, could the state prove these other acts by a preponderance of the evidence? And then two, Rule 403. Would this be, would the undue prejudice substantially outweigh the probative value of these other acts? So that's what we'll talk about today. Okay. I'm sorry, Ms. McCauley, you're up.
All right, Judge, so on August 21st or August 8th of 2021, Miss Wright reported that her daughter was playing outside with a neighbor's child. A family member of that child, identified as the defendant, told Miss Wright's child, so I'll refer to her as SW, to come into the apartment located at 768 Mercer Avenue. Upon the child SW going into that location, the child reported that the defendant began touching her on her chest, rubbing his hands all over her body, and telling her that she had a nice body and that she was going to be his. Investigators spoke with Anissa Porter, it's ANISSA, who identified the defendant, and she had also confirmed to investigators that the defendant had been at the residence on that date of the incident to babysit her children. SW was given a forensic interview where she provided a little bit more context as to what happened. She said that she was in the living room of Anissa Porter's apartment with her friend, another individual by the name of CJ, when the defendant, who she knew as Red, told CJ to go get something out of his car. Once CJ left the living room, the defendant then grabbed SW and began kissing her, touching her, in her, she specifically indicated her genital area, her breasts, and her buttocks over the clothing. SW also provided that the defendant gave her $20 and told her not to tell her mother. And then when CJ returned to the apartment, SW left the residence and made an immediate outcry to her mother. SW also identified the defendant out of a photo lineup as the individual who molested her. So that is the state's case in chief. It is allegations of child molestation, of touching over the clothes. The first transaction the state seeks to admit was the basis for the defendant's 01SC 10549 conviction for child molestation that actually was handled ultimately before Judge Manis of the Fulton County Superior Court for.
Is that the re-indictment of that 00SC case?
It is, Judge.
Okay.
That
Can you give me the 01SC number again?
Sure. It's 01SC 10549.
Thank you.
Yep. In that incident, it was reported that on July 1st of 2000, Mary Verdell and her then 10-year-old daughter, Tia Porter, TIA, arrived at APD to report that the defendant, who was Tia's father, had been molesting Tia during her visits to his residence. Tia described on multiple occasions the defendant engaged in inappropriate fondling and rubbing of her breasts and vaginal area. Tia further disclosed that the defendant had also performed oral sodomy on her and also had fondled other areas of her body, specifically her feet. Tia's brother, Xavier Porter, also witnessed some of the abuse, and both of the children were given forensic interviews. The defendant was subsequently convicted of 3 counts of child molestation on that previously mentioned indictment before Judge Manis on April 4th of 2011. So that's the first transaction the state seeks to admit under 414. The second transaction, the victim in that case is Anissa Porter, the same individual that the state referenced during its recitation of the facts of the case in chief. That incident occurred beginning August 2004 through October of 2005. That incident was received to law enforcement from a referral from the Department of Family and Children's Services regarding allegations of sexual abuse committed on Anissa Porter by her father, the defendant. DFACS was made aware of these allegations when Tia Porter reported to counselors that her sister had made a disclosure to her. Anessa was given a forensic interview. During that forensic interview, she disclosed being inappropriately touched by the defendant while staying at her grandmother's residence. She described that the defendant would place his hand on her vagina and buttocks under her clothing, that he would kiss her on the lips, that he would make her place her hand on his penis and would penetrate her vagina digitally. Anissa reported that the abuse began when she was about 6, and the last incident occurred when she was around 7 years old. The defendant entered a guilty plea to 1 count of child molestation on April 4th of 2011 for this incident. And I just want to verify, Judge, believe that relates to the indictment. Just a moment. In 06 SC 43692. So that was a separate indictment. And he pled to both on April 4th.
Of 2011.
Of 2011. There was a lengthy delay and an FTA. So
Okay, so the 01 SC and the 06 SC were both resolved in April of 2011.
Correct.
And they involve 2, I don't know how many daughters Mr. Porter has, but both of the victims are Mr. Porter's daughters.
yes, and one of them is a witness in the state's case in chief.
Okay, right, that's why I'd heard the name Anissa Porter. Okay.
There's a third transaction that the state seeks to admit involving a child who goes by the initials of MH. She's 15 years old or was 15 years old at the time. The incident was reported in August of 2020. It allegedly took place in May of 2020. It occurred at a location in Fulton County, and it was reported to Atlanta Police Department. It was reported to Atlanta Police Department by the defendant's ex-girlfriend, a woman by the name of Linda Hall. She stated that her 15-year-old daughter had received inappropriate text messages from the defendant. The MH disclosed that in May of 2020, she had visited 543 Burroughs Street to meet a friend who is related to the defendant while at the residence. The defendant took MH inside the apartment complex and lay in a bed with her while they were both fully clothed. The defendant placed his hand on MH's vaginal area and rubbed his hands over her body. And he also asked MH to touch his penis, which she declined to do. APD made a number of attempts to contact MH and have her forensically interviewed, and Ms. Hall would not allow that to take place, but the state has subsequently made contact with her regarding the pending 414 motion.
With her meaning Linda Hall or
Linda
now
Hall.
MH who?
We've made contact with Linda Hall.
Okay, and your representation is that, I don't know that Linda Hall has to say yes to it, but that MH would be able to testify.
She would be subpoenaed to testify. Yes.
Okay.
So based on all of those incidences, Your Honor, we would ask the court to admit the evidence under 414. Just going into the background and the purpose of the statute. So it's different from 404 because 404, as the court correctly stated, is allowed in limited circumstances. However, 414 is significantly more permissive. And it really comes down to the evidence in 414 can not only be used as similar transaction evidence of similar conduct by the defendant for one of the purposes set forth in 404, but also for the purposes of propensity. Evidence that a defendant has engaged in child molestation in the past is admissible to prove that the defendant has the disposition and character, and it makes it more likely that he in fact did commit acts of child molestation charged in the instant case. By the section's own language, evidence of the accused commission of another offense of child molestation shall be admissible and may be considered for its bearing on any matter to which it is relevant, and that's consistent with the jury charges for similar transaction evidence and specific to 414 evidence. So it's not limited to those specific reasons under 404B. However, in conducting the analysis, because a court has not issued factors to weigh 414 evidence, in looking just at the 404B factors in terms of for the purposes of identity, for the purposes of motive, for the purposes of lack of mistake or accident, for the purposes of motive, lack of mistake or accident.
Identity.
I already said identity, Your
Okay.
Honor, but thank you.
Yeah.
But even those limited purposes, this evidence is extremely probative. It definitely outweighs its probative value versus its prejudicial value in admitting it as 414 evidence. Not to mention the probative value of using the evidence for the purposes of propensity, to argue before the jury, which the state is allowed to do, that because the defendant committed all of these acts previously, it is more likely than not that he committed the act alleged in the indictment in the instant case. There is no requirement the defendant is charged or convicted of another child molestation offense for this evidence to be admissible. The fact that the defendant was convicted of not just one, but two separate convictions for child molestation, of which the conduct is incredibly similar to the conduct in the instant case, the state would not even necessarily be required to present those witnesses, but the state could in fact just enter those convictions onto the record. Although for the court's knowledge, the preference of the state would be to present the witnesses, at least the victims themselves, in the similar transactions so that they can provide that testimony to the jury and also be available for cross-examination. However, as it relates to that third incident, there is no requirement that the defendant be convicted in order for that offense and that conduct to be admissible. As to the prejudicial versus probative value and that balancing test, the courts have stated that exclusion under 403, that the fact that the evidence is so overly prejudicial that it outweighs its probative value. Rule 403 is an extraordinary remedy, and the court should only employ that sparingly since it permits the court to exclude concededly probative evidence. While it's still applicable under Rule 14, the courts have been instructed to liberally admit evidence of prior sexual offenses. As to whether or not it is fundamentally unfair, there is nothing fundamentally unfair about the allowance of propensity evidence so long as the protections of 403 remain in place to ensure that the potentially devastating evidence of little probative value would not reach the jury. And the example that the state has given in other cases is if the defendant had committed in a sexual offense involving an adult victim, say a constructive force or alcohol facilitated sexual assault on an adult victim, that would have very little probative value to incidences of fondling of a juvenile victim in a prosecution for child molestation. Whereas in this instant case, we have three prior transactions, all involving child victims, all involving female child victims, all involving female child victims that reported fondling of their intimate body parts by the defendant. That is consistent across all three transactions. So the fact that some of the other offenses might be a little bit more in terms of the acts might involve acts of penetration or acts that are more what the court might consider more forcible acts. Just because those acts exist doesn't necessarily mean that those facts create a prejudicial versus probative outweighing where the evidence should be excluded. The courts have given a balancing test for 414 evidence under Rule 403. It has not been adopted by the Georgia courts or by the 11th Circuit, but those factors include the similarity between the previous offense and the charged crime, the temporal proximity between the offenses and the charged crime, the frequency of the prior acts, and the presence or absence of any intervening acts, and the reliability of the past offense. So just moving through those factors very quickly, the similarity between the previous offense and the charged crime, I think, is self-explanatory at this point. The state has enumerated on that several times. The temporal proximity between the previous offense and the charged crime is a factor that these offenses are older than the offenses charged in the instant case, with the exception of the 2020 incident. That is very close in time, but it also demonstrates, it goes to that propensity issue. And just because an incident might be 20 years old or more doesn't necessarily exclude it. We look then to the conduct and whether the conduct is similar enough to maybe accommodate for that temporal proximity. The frequency of the prior acts, I think, is self-explanatory. When we have 3 prior acts over a 20-year period of child molestation involving 3 separate victims, demonstrates a frequency to commit these prior acts, which would not only go to the relevance argument and the probative value, but also the propensity value of this evidence. And then the presence or absence of any intervening acts The state is not aware of any intervening acts in the 3 incidences that the state has requested to admit in the instant case.
What would, I don't know what that, I know what those words mean, but what does that factor mean, an intervening act?
I think an intervening act of whether there's additional evidence as part of that act that the state is not seeking to include, such as, I don't know, a child molestation that occurs, and then the intervening act is, you know, the child becomes unavailable or unwilling to speak, or makes a recantation, I guess would be an intervening act. A recantation could be considered an intervening act. The court in this particular case, which is United States versus Kelly, 510 Federal Reporter 3rd edition 433, which is a 2007 case out of the 4th Circuit, really didn't define any further what they believe the intervening facts. Sorry, Ms. Rivers, am I going too fast?
Yes, can you repeat that site, please?
Sure. So it's 510 Federal Reporter, so F.3D 433.
Okay.
And it's United States v. Kelly. Kelly is spelled the usual way. Okay. And then the reliability of the evidence of the past offense. So in 2 of the 3 transactions, it resulted in a certified conviction. So that in itself is incredibly reliable evidence. And then the testimony, uncontested testimony of the 3rd victim would also be incredibly reliable evidence. So as to the 403 test, the state's position is that it has met any challenge that the probative value of this evidence would be somehow outweighed by a prejudicial effect of the evidence. And the state doesn't have any further argument for its presentation. If there's any inquiry of the court.
I may have one question. Let me look at. Do you know if the first 2 sets of transactions, because they weren't, I don't think they all happened on one day, if the 2 Porter daughters would describe an evolution of the contact? Because here's my concern, and then I'll explain what I mean.
Sure.
What is alleged in the case in chief is hands over clothing, which I think, if proven, is legally child molestation. So I'm not pointing out a weakness in the state's case. I'm focusing on a difference from the case in chief. And you've alluded to this, the first 2 transactions, where it sounds like if their testimony is consistent with what you set forth in the brief, both Tia and Anissa Porter will talk about something much more than hands over clothing. I'm curious if you know, Ms. McCauley, if it started with, if they'd say the first few times it was hands over clothing and then it was hands under clothing, or it was after I took a shower so I didn't have clothes, or if it was straight to body parts touching body parts.
So, Your Honor, I can answer that question if I could just have one moment. I just want to confirm one of the details for Tia Porter. Wrong indictment, that's why. So it's my understanding with Tia Porter that it was not necessarily, penetration did not necessarily occur almost immediately, that there was a progression of the abuse over time.
Okay.
And I think that was the progression that might have triggered the disclosure. Or it was the conduct of the child's behavior that triggered a disclosure. But I think there is a progression over time as it relates to Tia Porter. Now with Anissa Porter. I don't think that there was the same progression that there was with Tia, because it's a much shorter time frame.
Okay.
Yeah.
All right. Thank you for that answer. Mr. Porter, is there anything you want to say in connection with the state's notice of intent to introduce these other acts?
Yes, I would object to everything that she's just mentioned, because she's misinformed about a lot of things on that case. So.
Okay, well, let me start with some fundamentals. Are you suggesting that I wouldn't find, if I looked into the docket, 2 certified convictions for child molestation, one involving Tia Porter and one involving Anissa Porter?
Yeah, you'll find it.
Okay.
I have no problem with that.
Okay.
But I just want to clarify a lot of things that never got clarified years ago.
Okay.
23 years ago by attorneys.
Okay.
They knew better.
All right.
So on in November of 2000, the year 2000, I was arrested at 2291 Jonesboro Road, apartment D75. I was indicted for child molestation and reckless conduct by HIV on that indictment. No lawyer ever told me anything about that charge, because I never came to court on that charge. I stayed in jail for 9 straight months on that charge. On that indictment, they dead docketed that indictment in August of that next year in 2001. They re-indicted that case, and this is the case that she's talking about now in the 2001 indictment.
Okay.
The 2001 SC 15115. But that I don't have HIV. I've never had it. I don't have it now. Okay, nobody brought that to the attention of any court ever. This is the first time this has ever been told to anybody. So I just want to put that on the record.
Okay, let me pause right there. Ms. McCauley, you've made it clear you won't be trying the case. But do you think the state has any intention of exploring in front of the jury any allegation that Mr. Porter was HIV positive at any point, or that any of these situations, either the case in chief or the 3 instances of other acts, involved a risk to the alleged victims because Mr. Porter was HIV positive?
No, Judge.
Okay.
Okay, can I?
You can keep going. I just want to, I'm now more comfortable. I understand your frustration with that, but if that comes up at trial, it's because you bring it up, not because the state brings it up.
While I was in jail, because the state has put it in their notice of intent to introduce these other acts, they put it in their motion about something that happened way back then, and no lawyer, again, nobody clarified any of that. It needs to be clarified and corrected. I stayed in jail. While I was in jail from 2000 to 2001, my mom moved from 2291 Jonesboro Road to 571 Farnwell Street, Atlanta, Georgia. I gave that address to the court at my next court appearance in open court. In 2003, she moved again, and I gave the courts the new address of 1212 Galt Street on Boulevard in Atlanta, Georgia. At my next court appearance, I received all subpoenas at that address, and I never missed a court date from 2001 until 2005. When for some strange reason, the DA's office say they sent me a subpoena to appear somewhere in 2005. And it was apparent from the clerk's file this is a part of the clerk's file, that it was sent to the wrong address. I was never called by my attorney about a subpoena. There was an FTA warrant issued in 2005. My lawyer still never called me, nor came to that address on 1212 Galt Street and told me anything. I was arrested in April of 2006, and I remained in jail for 5 years on all of these mistakes, and still no one told me anything. The state violated all of those constitutional rights in the First, Fourth, Fifth, Eighth, and 14th Amendment, but still no lawyer told me. Now this DA wants to use that against me to deny bond and all of these things about this, because they say that I was a fugitive.
Okay, so I want to keep us focused on the 414 notice. While Ms. McCauley did make reference to the fact that there was some point in time where it seemed like you couldn't be found, that was only because I was confused by the timeline, that there were these pleas in 2011 to a case from 2001, really from 2000, but an indictment in 01 and an 06 indictment. So Ms. McCauley was giving me some context. If you want me, Mr. Porter, to preclude the state from sharing with the jury that in someone's mind, it must have been a judge as well, because the judge would have signed a bench warrant, you were a fugitive, you had failed to appear. I'm happy to do that because that's not relevant. The fact that for a little while you couldn't be found. So I don't want you to worry about that. That's really not part of any of these three other sets of acts. What the state would be limited to presenting would be the facts and circumstances around the conduct that resulted in the case you pled to involving Tia and the case you pled to involving Anissa. Not, and it didn't plead for 5 years or he was a fugitive. That's not relevant to this conduct. So I'm not saying don't be frustrated by the things you've described, the HIV allegation or your efforts to keep a current address in the system, and maybe the system didn't reflect your efforts. But once you start going down this path of I was denied my constitutional speedy rights, that's for a case you already pled to. So that ship has sailed, you pled to it. And there may be reference to the fact that you pled guilty in 2011 and it's an 06 case, but it's not a matter for the jury to wonder, well, why was the plea not until 2011? It's just not. If you want to explore with the jury why it is, I guess you could if the state doesn't object on relevance grounds. What is relevant about these other acts or what it is that you allegedly did to Tia, to Anissa, and to MH. And that's what the focus will be.
But that still goes to bond.
Okay.
They're still using something that's a lie.
We're not talking about bond right now.
Now, I understand, but
okay.
It still needs to be clarified. Okay. Somewhere, sometime, it needs to be clarified.
Well, you're doing some of that now.
Okay. Rule 404B evidence. It is the most frequently appealed of all evidentiary rulings, and the erroneous admission of evidence of other acts is one of the largest causes of reversal of criminal convictions, uncharged misconduct evidence.
404B, I think you're getting some traction with what you're saying, but this is not 404B. I gave the little soliloquy at the beginning of this just to help frame this, that we're in the rare air of 414, where there are precious few reversals because the state can seek to admit it for any purpose. I'm just looking at whether the state could prove it by a preponderance, and it sounds like they could. They run the risk if Anissa Porter comes in and says nothing happened. But in opening, the state said, you're going to hear from Anissa Porter, and she's going to say that her father did these bad things, and that doesn't happen. Maybe there'd be a mistrial, but I don't think they have a proof issue. And then we're really limited to Rule 403. Is that undue prejudice, does it substantially outweigh the probative value? So I didn't mean to cut you off, but if you're going to share with me The appellate court struggles with trial court's rulings on 404B. I'm aware of that, but this is not 404B. And so they won't struggle in the same way.
Under 413. It can't be
413 or
used-
414?
413.
Okay, we're traveling under 414.
I understand.
Okay.
These are all under federal rules of evidence.
Okay.
This is evidence that she's trying to bring in under Title 24.
Okay, so not the federal rules, but the Georgia rules.
But they were adopted by the state courts, the federal rules.
So in 2013, Georgia did adopt a new evidentiary code that was modeled in large part off the federal rules. It was not a wholesale adoption, just photocopy the federal rules and put them in there. There were some changes, but you can talk a little bit about 413. It's really not what we're here for, but I'll listen a little bit to 413.
It says, evidence of other crimes, wrongs, or acts shall be admissible to prove the character of a person in order to show action in conformity therewith. It may be admissible, not that it is. It may be for other purposes, including proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. 244403. You'll find this case, statute in Hood versus the state. This is a Georgia Supreme Court case, Hood versus the state, 299 GA 95 2016. Relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, because it's only used as cumulative evidence. Each case should stand or fall on its own merits. And I asked the district attorney, were you thinking about adding these old cases when you locked me up? Of course not. You probably didn't even know about them. You locked me up based on the evidence you had in this case. So why is there a need, which you must show this need? Now, for these the 01 and the 05 cases, the old cases are irrelevant to tie these distant cases together. And they are only being added because they are of the same species of crime. Not that proving a same element in the old tends to prove any element in the new. It said in 2414.8, 2 or more witnesses are required to convict in felony cases. The testimony of a single witness shall not be sufficient. And this is especially true when there are no corroborating circumstances. 24.403, again, it would be prejudicial to include the 01, and 05, 06 cases because of the danger of unfair prejudice and the needless presentation of cumulative evidence under the guise of a similar transaction. If the state says it's used for intrinsic purposes to show intent, bent of mind, or course of conduct, this court must look closely at why the state needs these cases and what purpose would the need identify in the instant case. Notably, the old cases are not a part of a same crime or event. They are not intertwined, not a series of crimes or events as a single transaction of the charged offense or offenses. Plus the old cases are 20, 22 years old and 18 years old. The state is trying to enter. They can't be used to complete the story. What will be the same evidence used from the 2001 and 2005 cases respectively to show a continuous link in a string of crimes? The reason for 24.403 was to limit scant or cumulative probative force. And if a similar transaction is allowed, then it can directly be shown that it's only used for its prejudicial effect and not that one's evidence tends to shed light on the other. There is no tie that binds these cases together. All these cases are not a part of a single continuous criminal episode and can't be used as intrinsic evidence. The facts in the cases are different. All the crimes have one common element, and that's intent. So said Leo Ward Sears of the Supreme Court of Georgia. They're all tied by intent. That's any case. So I would respectfully ask this court not to allow. Take me to court for what you say I committed. Take me to court for it. And if you can convict me, give me a life sentence. You can take me out in the back and shoot me down like a dog. I wouldn't even care.
Well, that's not how this one's going to play out.
But I'm just saying, you know, I mean, yeah, I know you get the gist of it.
I do. I understand your point. Okay. You've done some serious legal research. Ms. McCauley, as the movant/noticeant, whatever the word would be, party filing the notice, anything you want to add?
Sure, Your Honor. The legislature has acknowledged the seriousness and the pervasiveness of sex offenses in enacting 24-4-414 and expressly committed that or created that statute to allow the evidence to be used for the purposes of propensity. And while the state is intending to try Mr. Porter on the allegations listed in the indictment, the state has a right, as authorized under the statute, to ask for additional evidence to be presented and considered by the jury that goes to the defendant's propensity to commit these offenses. So that's the state's only rebuttal to Mr. Porter's argument.
Okay. And should I allow any of it in, I'll also be instructing the jury that they are to consider only the charges in the indictment and not the other acts evidence as they're figuring out whether the state has met its burden. Okay, Mr. Porter, I did say at the outset of the hearing that I check in with you to see if there's anything else you see on the horizon. I am anxious, as are you, I know, to get this case in front of a jury. I need to rule on the state's notice, and then I think we're trial ready. Tell me your thoughts about that.
One more thing, Judge, if I may. This is the gist of the whole matter. The United States Supreme Court, they explained over 60 years ago that the state may not show a defendant's prior trouble with the law, specific criminal acts, or ill name among his neighbors, even though such facts might logically be persuasive that he is by propensity a probable perpetrator of the crime. The inquiry is not rejected because character is irrelevant. On the contrary, it is said to weigh too much with the jury and to so over-persuade them as to prejudge one with bad criminal record and deny him a fair opportunity to defend against a particular charge. The overriding policy of excluding such evidence, despite its admitted probative value, is the practical experience that is disallowance tend to prevent confusion of the issues, unfair surprise of 10 days to give me notice before trial that these old cases will be used and undue prejudice. This is in Mickelson versus the United States. And that site is 335 US 46969 SCT 213 93 LED 168 1948. What material fact is at issue here? While Mickelson preceded the new 404B rule, it still provides the historical context behind the prohibition of such evidence that 404B seeks to allow. Similarity to the old charges is still a similar transaction under any guise or any statute. And mere similarity is not an exception to the character rule. See Amy versus the state. That was something else that I US, there's a US case, a United States versus Facnicone. This is 11th Circuit case. And it states in that case there that there must be a signature that is unique only to me to admit these old crimes after 20 some odd years. It's called a forbidden inference. And you can't unring that bell. If you say that, if you bring those cases up and that jury is sitting over there and they hear it, you can't unring that bell with any instruction from the court. They're going to take that back there in that jury room with that in their mind. And that's what I'll get convicted of, not the case in chief. I will be convicted of it, and I know that.
Okay. All right. Any other topics? I've heard you on that. I'm familiar with Facnicone, and I'll take a look at that Supreme Court case. Tell me if there are other topics that we ought to cover, because when I see you next, it will probably be to say we're starting trial next week, and just checking in with sort of a pretrial conference.
And under those old cases, I would say res judicata, issue preclusion, collateral estoppel.
When you say those old cases, meaning using
2005 case,
using the first two other acts,
Yes.
in this case, you're saying that's what you're talking about now?
Yes.
Okay.
Those cases are dead. They're over with. I've served my time for those cases. And there's no issues in those cases that can be brought back up again. It steps on double jeopardy. You're bringing them up because you're still litigating them. And they can't be relitigated.
Okay. No, I'm following you. I don't know that I agree with you, but I'm hearing you on that. Okay. Anything not about 414 that we need to cover today? Or you understood today was 414 and you filed your motions and you're ready to go?
Judge, there's a number of motions that I filed that have never been heard.
Okay.
Many. They're still on the docket.
I feel like I went through it pretty carefully. There were some that were duplicative, and so I didn't address each of them. You mentioned a species. They were of the same species. So you have filed a number of things saying, hey, I want a speedy trial, or I'm entitled to one, or my right to one has been violated. I've addressed that. You have filed some things asking the clerk's office for information. I guess you could call that a motion. There's nothing I rule on. That's a request to the clerk's office. We worked through your demurs. I'm not remembering everything, but I didn't feel like there was a category of motions that I hadn't addressed. Why don't you give me one example?
I filed a motion.
In this case?
Yes, in this case. I filed a motion to remove counsel in I think it was February of 2022.
To remove counsel, meaning remove your counsel?
Yes, to remove counsel of record.
Okay.
Because I invoked my rights to not have counsel.
But haven't we navigated this as well? You now represent yourself.
I understand. All I want you to do is understand me. That's all I can do is try to get you on my page.
Okay.
I'm on yours. I just want you to try to get on mine and understand where I'm coming from.
Okay, let me try to get on your page.
Okay. I go into first appearance. I was arrested on 12/4/21. Went to court 2 days later, 12/6/21. I'm in the hearing, first appearance. I tell the judge and the lawyer that's supposedly representing me, I don't want you. And the judge didn't address it. He said he didn't think that he could. But I told him that I wanted a speedy trial on that date. My rights kick in the day that I get arrested. So all I can do is claim those rights. And that's what I did.
Sure.
Now, all of that has been held against me for claiming my own rights.
When you say held against you, what do you mean?
I think last time I was here and a previous time before that, this court, you said that, well, Mr. Porter, you didn't want the attorney. I said, but you still gave him to me. And that was a violation of my rights. You forced the attorney on me when you knew I didn't want it. I told the judge, I told the attorney that filed an entry of appearance the following day. And then don't do nothing. Don't come see me. Don't do anything.
Right, I've heard about. That was documented in my order on what I fashioned as the plea and bar, the motion about the constitutional speedy. But tell me what relief you think you should get now about the fact that you had a lawyer that you didn't want for a number of months.
That was almost a whole year. Not just a number of months.
Okay,
And
let's
so-
say 12 months. I don't know that that's right,
Okay,
but
this is
I'm
about
gonna be on
9.
your page. Your page says 12 months. You had a lawyer you didn't want.
Exactly. But you forced him on me. The lawyer did nothing. My witnesses are gone. I didn't have a chance to even talk to any of these people. The lawyer did nothing. Then I claim that I was denied counsel because no counsel did anything for me. But they were there on my case as an entry of appearance. And their duty under the Constitution of the United States and the Georgia Constitution is to do their job. And nobody did their job. I sent 2 subpoenas to these 2 attorneys that I'm supposed to have that court said that I didn't want, but they were still there and they did nothing. I sent subpoenas to them. I sent them to got them from the clerk, which I have a right to do. And I sent them to the clerk. The clerk didn't send them. She threw them away. I know they threw them away. They're not even filed, period. I have a docket report on it. Didn't even file them. I sent 2 to Miss Lee A. Feely. I sent one to Miss Tanya R. Jones, public defender. And I think you said this last time I was here, she came in and she said she didn't get them. Of course she didn't get them. They weren't sent. I had one in that that I sent to my daughter. She didn't get hers either. But I sent one previously
Right,
to
so
her.
we covered this as well when we had the Ferretta hearing, when you at last had your request honored to represent yourself and free yourself from the lawyers that you didn't want, that getting subpoenas served was going to be complicated for you. And you're now experiencing that. I'm not aware that it's the clerk's responsibility to mail out your subpoenas. You may have legal authority for that, and that's something that you could take up. But my question was, what are the motions that I haven't ruled on? And so far, you've said there's one about wanting to be relieved of counsel. I pointed out that, in fact, you are relieved of counsel. So I guess I'm happy to orally deny that as moot. You don't have a lawyer right now. You've got you. What else did you want to cover?
And for the record, Judge, this is the second time that I've come to court with no notice. I don't even know what to bring sometimes.
Well, it looks
Because
like
I
you
don't-
brought everything, which is smart, because then you'll have it all.
Exactly, just in case.
Right.
But what if I leave anything over there because I have another case in Judge Swall's courtroom?
So we'd reset if you weren't able to bring what you needed to bring. I don't know how to give you notice. You're representing yourself. I know how to give your lawyer notice, but there's not a way to get you notice.
The mail still runs.
Okay.
I mean, you sent me one once before.
You received notice at the jail before?
Yes.
Okay, well then we
I
need to
know.
make sure that that happens. And I'll talk with my team to figure out how we can make sure we at least send it. Does the jail deliver it? Don't know. That part I don't control. I'll make sure we get something to the jail. But I'll tell you, I don't envision you coming back here many more times. It'll probably be, and we may do it virtually. That'll just be easier. That pretrial conference, make sure there's nothing else left. And in that pretrial conference, I'll be able to tell you, hey, you're going to come over here for your trial on this day. So you'll hear it from me directly. And that way there won't be any surprise. And if you're going to want to be wearing something other than what you're wearing, you'll know how to line that up, or at least you'll know you need to line that up because that next trip on the van will be for your trial. Okay.
Understand? There was one more thing. Could you send an order over to the jail for the law library? Because it's impossible to get the machine in our dorm is out every week.
What machine?
The law library. You can go on the computer and do your case law searches and all that type of stuff on
Sure.
fast case. And I need to be somewhere where I can do, because it's noisy. I'm talking about super noisy.
All right, so
Fighting
you're starting to slide into that space of, I told you so.
Yeah, I understand all that.
Okay.
You remember, but still, I should be allowed to go to a law library.
You should, but I'm confused. I'm hearing you say in one way, the machine is broken. I assume by machine, you mean computer, so you can't do research. But then I heard you say, well, actually, it's what it is it's noisy, not the machine, but around you, it's noisy. It's not like a library you'd see on TV where people go, shh, if you're loud, because it's space in a jail and other people there aren't particularly interested in being quiet. Maybe that's one of their few freedoms, is that they can be loud. That's a consequence of you being your own lawyer while you're in jail. Now, if you're telling me that you put in a request each week, I'd like to use the law library, and the sheriff's team says, no, you can't, or they do the functional equivalent, they say, sure, and they bring you to a room that's empty, I'm happy to get involved there, because you are entitled to some access to legal resources. I'm happy to hear that there are computers there. Back in the day, you might go in a room and there's some law books. I don't know how helpful that would be if it's about civil cases and you're in jail. So tell me what your specific request is, because I'm not going to tell the sheriff, hey, you need to keep it quiet for Mr. Porter.
No, I have no problem with that. My thing is this: pro se litigants at the same jail, they're allowed to go to, there's a law library in there as big as this room.
Okay.
And they're pro se litigants are allowed to go there to do their research, to make copies of documents and all of these type things, to get notary and all of that. I put in a request about 3, maybe 4 times. It took 3 months to even go.
Okay. Let me find out who I need to reach out to, and we'll figure it out.
She'll appreciate it. Okay. And that was a motion that that I filed that I've never got any no copies of it, no ruling on it, no nothing.
When would you think that you filed it?
That was last time I was here, I filed 4 motions, and I only you ruled on 2. And that was it.
So February 7th, you filed the general demur, ruled on. Motion, your plea and bar, ruled on.
I never got any copies of that.
Okay. Again, you're in jail, but I'll print out the order now, so you'll have it. And then you had some motions in limine, and those have been ruled on. You were trying to keep out the child hearsay. The child hearsay is coming in. And
it was one motion in limine I never got a ruling on.
Okay, I'm gonna print out. I got 4 orders that I entered. I'm gonna print them all out just in case you didn't get them. Before you go, you may go back into lockup, but I'll have Deputy Gordon keep you up here while I go print them out. I guess I can't staple them, just give them paper.
Yeah, that'd be fine.
Got it. Okay. So I'll get you those, and I will look into increasing your access to the law library, maybe getting you to that hallowed ground of the law library you're describing that other people are able to get to. Okay.
And one more thing before I go.
Keeps being one more.
Yeah, just one more thing. I have to. I mean, it's not like I come to court every day. You know what I'm saying? So
I do know that you don't come to court every day.
Yeah. So I'm full of things.
Okay.
But if you denied the motion to dismiss on the speedy trial grounds.
I did.
Okay. So I've never had a copy of it. So that's time off. And I will be appealing that. So I'm asking this court for a certificate of appealability to the for the
just to manage your expectations. That'll be a basis to appeal after your trial. It's not going up before your trial. Okay.
But I can't appeal before I go to trial?
I don't know. I'll look into that. But if I have any discretion, we'll do your trial first. Okay.
Oh, wow. I've never heard of that one.
Oh, there are a lot of things where it's discretionary appeals. And I'm going to do the right thing. If it is clear that if you want to appeal that, you have a right to do that before we go to trial, you can do that. Of course, the time that involves, the months and months and months, that doesn't add to any future appealable delay to your trial. So I will get you those 4 orders, and you'll file whatever you file in connection with that. Okay.
Because I don't want to lose any right that I have. So if I have the right to appeal, I want to appeal.
So a couple things on that. I'm not giving you legal advice, but I don't know that you waive things. For example, you had a motion to suppress and I denied that. You can certainly appeal that ruling after your trial. It's just common in post-trial litigation. Hey, this stuff came in at trial because the judge wrongly denied the motion to suppress. Now, we will soon, but we don't get right now a whole lot of constitutional speedies. And so I'll just need to make sure I'm clear on the effect of your notice of appeal. If it is one that immediately and without any say from me pauses the proceedings, or if it's one, like you mentioned, where I would issue a certificate of appeal. Don't know. We'll figure that out. Okay.
Because there's a 10-day rule on it.
Yeah, I guess you'd have to navigate that one as well.
Yeah.
All right. Before you get up, Ms. McCauley, anything you want to add in connection with anything we've been discussing?
No, Your Honor.
Okay. All right. So Mr. Porter, you're going to sit tight back there. I'll get you these orders and we'll go from there.
Okay.
Please don't schedule us in June for this trial.
What's wrong with June?
It's already up on 2 older cases in Lethbridge.
Oh,
For
okay.
the first week of June. And then I'm going to be trying a case for the month of July in Barwick. So
The whole month?
starting July 10th. It's a cold case child homicide with a pro se defendant.
Okay. We do need to get Michael Reynolds scheduled.
I know, I talked to Ken. He doesn't have any of the discovery from the conflict defender's office, so I made him a duplicate copy of everything and I pulled everything off the docket and I just have to send it to him.
Okay. So he as of right now doesn't have discovery.
Have it by Friday.
Okay. How is it? Lots of medical stuff?
Medical, there's videos, MARTA video and then a gas station video. There's a lot of interviews, audio and video recorded interviews.
Okay.
There's probably 12 interviews.
Okay. So he's got lots to consume. Is there anything from your knowledge of the case where he's going to say, I need to get experts to look at this? I don't remember if it's shaken baby or star baby
It's
or
blunt force
baby's
trauma.
head removed.
It's blunt force trauma to the abdomen.
Let Ms. Rivers go. Thank you, Ms. Rivers.
Sorry, Miss Rivers. I sent you an email.